Good afternoon and welcome to the Appellate Division, First Department. We have 7.5 hours of requested argument time, so please ask for what you need, not what you want, understanding that the clock is for you, not for the court. So if your arguments are so brilliant that my colleagues have more questions, I let the clock roll, okay? We are also going to be calling a case out of turn, number 10 on the calendar, Batista versus Bulgos. That case will be called first as we require a Spanish-speaking interpreter and want to be able to release the interpreter for other services. All right, so now the call of the calendar. People versus Ayana Clinton. Submitted. Yemeni versus Yemeni American Association versus Alcede. Submitted. A. Louisiani versus Jonathan C. is submitted. Bola versus Tully Construction Company. Okay, how much? All right. 5 and 2 and 5. Beach versus Taraji Capital Management.
Appellate, Your Honor, 5 and 2.
Okay. And if I mangled the name, my apologies. Sebastiano versus Schimmerhorn, LLP. Okay. 5 and 2 and 5. Thank you. People versus Malachi Williams. Submitted. Capitus Servicing versus Suburban Waste Services. Okay. 6 and 1 and 5. Batista versus Bulgos. How much time? ¿Cuánto tiempo? And forgive me, I can't help but understand, so I broke out in Spanish, but we will be speaking in English. Okay, and how much time would you like, sir? Okay, we're going to do 5 and 2 and 5, and let her know, as I said, explain to her that if the court has more questions, I will allow the time to continue. Okay, and her case will be the first case called, but I still have to finish the calendar so she can have a seat. Okay? All right. Rodney versus Usichi. Submitted. People versus Anthony Henry. Okay. 6 and 1 and 6. Reg Park Lender versus Golian. Okay. All right, let's do 6 and 1 and 5. Hamilton versus Premier Home Health. Okay, how much time would you like? 5 minutes. People versus Brian Thompson. Okay. 5 and 1 and 5. K versus Citibank. Okay. Do you have a cross appeal? No, we simply would request the same amount. 7 and 2 and 7. There's a reason there's rebuttal time. Thank you. People versus Darrell Dean. Submitted. Global Bank versus 43 Mott Realty. Okay. 4 and 2 and 5. Rejo versus YYY 62nd Street. Okay. 5 and 2 and 5. People versus Mororrow Bavar. Okay. 5 and 2 and 5. 3502 Partners versus MTA is submitted. We're calling the first case out of order, Batista versus Bulgos. She may come up to the mic and proceed.
Buenas tardes a todos los honorables jueces.
Good afternoon to all the honorable judges.
Esta apelación surge de una orden que negó el juicio sumario mediante un análisis procesalmente inconsistente y jurídicamente defectuoso.
This appeal arises from an order that denied summary judgment through a procedurally inconsistent and legally defective analysis.
Aunque se plantean múltiples errores, el problema central fue la falta de análisis judicial independiente exigido por CPLR 2219A.
Even though this stemmed from several errors, the main error was the lack of analysis, judicial analysis from CPLR 2219A.
La apelante cumplió con su carga inicial bajo el CPLR 3212 y los demandados no lograron crear una disputa real de hecho material con evidencia admisible.
The appellant met her main burden under CPLR 3212. The respondents failed to raise the tribal issue of material supported by admissible evidence.
En lugar de aplicar el estándar correspondiente, la Corte negó la moción por motivos procesales mientras analizaba los méritos.
Instead of applying the governing summary judgment standard, the Supreme Court denied the motion on procedural grounds while simultaneously analyzing the merits, riled inconsistently on the note of the issue.
Adoptó la narrativa de los demandantes sin explicar por qué la evidencia del apelante era insuficiente como cuestión de derecho.
And adopted the respondent's narrative without explaining with appellant's evidence why it was insufficient as a matter of law.
No estoy aquí para llamar a reevaluar los hechos,
I'm not here to reevaluate the facts,
sino para que se corrijan los errores legales y procesales que causaron perjuicio y afectan la revisión apelativa.
but instead to correct the legal and procedural errors that prejudice appellants and undermine meaningful review.
Por eso corresponde la revocación de la orden.
For that reason, that will lead to the revocation of the order.
Ask her if she has anything else that she wants to say to us.
¿Hay algo más que le gustaría decirle a los jueces?
Estoy un poquito nerviosa.
I'm a little nervous.
I understand you're doing very well.
Está haciendo muy bien.
Realmente se cometieron múltiples errores
Truthfully, a lot of errors took place
que perjudicaron y todos remontan, esos 9 errores remontan a un punto que fue el de la falta de análisis independiente.
and all those errors led to one point, which was the lack of analysis of the case.
Lo que también lleva a la violación de el due procès.
That it's also a violation of the due process.
Due process.
Due procès.
Okay. All right. Let her know that she's almost out of time, and I'm going to hear the other side, and then I will give her time to respond to the attorney's arguments.
del abogado.
Okay?
¿Está bien?
Sí.
All right, you
Yes.
can have a seat.
Puede
Okay,
sentarse.
thank you.
Thank you. You may
Good a-
proceed.
Thank you. Good afternoon, Your Honor. It's Mark Vaughn from Shira PC for the respondents. Briefly, despite the numerous issues raised by the appellant in her appeal and her papers, which I note, and the court will note, go way beyond the order that she is appealing, and that order simply was denial of her summary judgment motion and the respondent's cross motion for summary judgment. The one issue that the appellant ignores in her papers is at the time that she perfected her appeal, a final judgment had been entered in this case. There had been another motion for sanctions against the appellant for her refusal to appear for her further follow-up deposition or completion of her deposition and her physical examinations. An order was entered granting that motion, dismissing her action as a sanction for that, and a final judgment was entered before the appellant perfected her appeal. That's it, and she placed those in the record at 731 through 734. Both were served with notice of entry at the time they were entered. The appellant failed to serve notice of appeal for either the order or the final judgment. And as this court knows, the failure to do so is jurisdictional. It's discussed in my papers. The other issues discussed in my papers, the case law from this court and from the Court of Appeals, all note that the appellant's right to appeal the interlocutory order denying her motion for summary judgment terminated upon entry of the final judgment, which again I note she never bothered to appeal. So based upon that, this appeal must be denied. But if the court does entertain the appeal of the order regarding summary judgment, I note that, like the appellant, I also agree that the order was erroneous. However, I believe it was erroneous in a different manner. The court will note from the record on this appeal, particularly at 692, that in support of the cross motion and in opposition to the appellant's motion, there was submitted sworn interrogatory responses by Mr. Bulgos. Mr. Bulgos discussed under oath how the accident occurred. The appellant, on the other hand, during her deposition and during another under oath examination before the lawsuit was filed, repeatedly testified that she had no recollection as to the accident happening. She recalled leading up to the accident and she recalled after the accident, but she had no recollection of the accident itself. The only evidence before the court below was the sworn response of the respondent that the appellant had swerved, entered his lane, sideswiped him, and was the cause of the accident. If anything, there should have been summary judgment for the respondents, or at very minimum, there was an issue of fact raised by that, such that the motion, the appellant's motion, was properly denied. Thank you.
Okay. You have 2 minutes.
No soy abogada.
I am not
Voy
a
a
lawyer.
usar un término. Cuando tú estás construyendo una casa, si la zapata está dañada, la casa se va a derrumbar.
I'm not a lawyer. I'll use regular terms. When you build a house and the foundation is not solid, it will collapse.
Esto mismo sucede con los argumentos de la oposición de los respondan.
That is what's happening with the arguments from the opposition, from the respondent.
Él está relitigando, pero además acerca de la orden final.
He's relitigating, but about the final order.
Lo que trajo un final judgment
What brought the final judgment
no impide la apelación, primeramente porque fue basado en todos los errores que se vinieron cometiendo antes.
Does not prevent the appeal. First of all, because it was based on all the errors that were committed before.
No voy a responder a los argumentos de el que está trayendo acerca de si recuerdo o no recuerdo de si hubo una declaración jurada post disposición, después que me dispusieron, hubo un cambio. No voy a entrar en esto.
I will not argue about what I do remember or don't remember about the accident or about declarations under oath.
Aquí la base es, no hubo una independiente, una, ay, Dios, se me fue la palabra.
There wasn't any independent
Analysis?
Análisis judicial independiente.
there was no
Y esa es la base de esta apelación. Y los récords
there was no independent judicial analysis, and that is the base of my appeal.
and the brief lo demuestran claramente.
And the brief demonstrates it clearly.
Thank you. You're out of time, but we have your papers and the other side's papers, and the court will take a look at it and render its decision.
Muchas gracias. Tenemos sus papeles y los papeles de la respondiente y vamos a analizar.
Thank you so much.
Muchas gracias. Puedo regresar atrás.
Okay. Bola versus Tully Construction. Counsel?
Good morning to the court, to counsel and the court officers. May it please the court, my name is Vincent Fitzpatrick. I'm from Mullen Arms and Fitzpatrick, and I represent the appellant Louis Bola. This is an employment retaliation case. Supreme Court decided in error and granted.
Counsel, in terms of the retaliation, what was the complaint that your client made for which he was retaliated against?
My client made several complaints. The record shows that my client called his supervisor, respondent, Mr. Ryan, 3 to 4 times a week in the months preceding his termination. In addition,
And what complaint did he make when he made those calls?
so Mr. Vola described a sort of lawless environment in which safety compliance was a non-factor.
Well, his role was to enforce safety, right?
That is correct. He's a safety
And a
officer.
part of his role included him making phone calls to his supervisor where he saw potential safety hazards.
I think that that's correct, Your Honor. However, I think that this goes a step beyond. I think that the record shows that Mr. Vola had difficulty with his coworkers because they were not listening to him. They didn't like him. They didn't like the way he enforced safety. They didn't like that he was
I
enforcing
mean,
safety.
according to the record, they didn't like the language that he used in speaking to his coworkers, right?
Your Honor, I think that one could reasonably take that, but I also think that the record supports that they had animosity toward him because he was enforcing safety standards.
So in terms of the retaliation claim, let's get back to that.
Sure.
Outside of his responsibilities, which was to report any safety concerns, what actual labor law violation did he report for which he was retaliated against?
Well, I think that the actual violations are under sections 200 and 240 sub 6, which requires an owner or a contractor to provide a safe workplace for their employees and for their workers. And that's in Mr. Vola's complaint. And here, I believe that the record establishes that he did just that. Now,
Doesn't the record also establish, as my colleague has pointed to, that it wasn't a singular complaint of his abusive language with workers? This was a pattern, apparently, from job site to job site, where there were complaints at every job site look, his job was to say, you're not doing that right, that's a safety hazard, so that's always gonna create tension, right? But it's how you talk to people, right? And the record is replete with evidence that he didn't know how to talk to people, right? And it got under people's skin.
Your Honor,
Right?
I believe that the record also,
I'm correct about that. The record does give us a lot of examples about that.
I think, correct, Your Honor.
And if those examples are accurate, that certainly would be a basis for the job action that was taken against him, if they are accurate.
But Your Honor, that's the key, if they are accurate. And that determination is a factual determination that's in the province of the jury. And when the Supreme Court instead decided to weigh that testimony over plaintiff's testimony, that's error, because that factual determination is for the jury. The Supreme Court instead viewed the facts more favorably for the respondents, which is
Counsel, as a matter
contravention
of
the
law,
standard.
though, the second retaliation claim is based on an incident that happened after he left the employ. You'd concede that there's no 215 claim from that, right?
I no, Your Honor, we do not concede that.
What case permits, after employment is over, such a claim?
Your Honor, I
Under
think,
that particular section. I mean, you may have some other kind of claim, but on that section, how do you get there if you're no longer employed by them?
Your Honor, I think this is how we get there. Now, this court held in Vergara versus Mission Capital Advisors that does not constitute a cause of action. However, in finding that, this court relied on other courts in New York, primarily the Eastern District, I believe. And I submit that other courts in New York, under a similar survey,
Other
hold
courts
otherwise.
outside of the first department?
That is correct.
So you want us to abandon our first department case law for another department's case law? When have we ever done that?
Your Honor, I suggest that this,
I'd like you, if you can cite one case, I'll hear you.
I can't cite that for you right now,
Okay.
Your Honor, but however.
You're gonna have a chance on rebuttal, because you're out of time.
Thank you. Thank you, judges.
Counsel?
May it please the court, Ryan Sopke, Cullen and Dykeman on behalf of respondents. I will be brief. As the court's already noted regarding appellant's first retaliation claim, there is no question that appellant's job duties were to be present on Tully job sites, observe safety issues, and correct those safety issues. That is clearly not the same thing as making complaints about safety and the conditions that he was forced to work under. In regard to counsel's comments about conflicting testimony,
Oh, he did. You're not suggesting that none of his calls were appropriate. And in fact, the record shows that Ryan responded to some of them and had to make phone calls himself to make the workers do what this gentleman was trying to get them to do.
right, but that was appellant's job. Appellant's job was to correct safety issues on the job site. It was not, as the law is intended, to make complaints every time he did so, such that it would be considered a protected activity under the labor law. In that situation, a safety manager like appellant would be engaging technically in a protected activity under the labor law just simply by performing his job duties, which I don't believe was the intent of the law. Appellant relies solely on his own unsupported testimony to support his version of these events. He does not cite to any witnesses that support his version of the events. He does not cite to any documentary evidence that supports his version of the events, while respondents have produced several forms of documentary evidence in the form of emails and employment records, as well as several affidavits from other witnesses that all establish that appellant's language and his conduct towards other Tully workers was aggressive, abusive. These simply aren't issues of fact for a jury.
Had this plaintiff been warned in the past that he needed to refrain from using abusive language and aggressive language and demeaning the employees?
Yes, Your Honor. In fact, there's an email that we produced from July of 2019, just a mere few weeks before appellant was terminated, and that's at the record at page 104, from Mr. Ryan, who was appellant's supervisor, to appellant, in which he stated that he needed to, quote, work on his approach and he listed several other incidences where he had received complaints from others on job sites about the way that appellant had spoken to people on those job sites, about his language. Mr. Ryan specifically asked for appellant to soften his approach and change the way that he spoke to people. Appellant did not respond to that email, and the activity just kind of went forward as
Were there instances where the same conduct took place in different job sites?
Yes, this was a pattern across all of Tully's job site. Any job site, and I believe in that email, Mr. Ryan specifically lists the job sites that the appellant was assigned to, where these were issues. There was at least 3 or 4 different job sites where this was a problem, working with all different people from Tully.
Can you address the defamation claim?
Yes. The defamation claim, on his appeal, appellant asked the court and suggested the lower court should have essentially read the statements at issue in a vacuum, which is clearly not the standard. The entire context needs to be taken into account.
But even if you don't read it even if you do read it in context, isn't there some defamation per se, or at least an issue of tribal fact concerning his professional competence?
We would submit no, Your Honor. That we cited to a few cases in our brief in which I believe, one from the Court of Appeals and several others from New York courts, where general comments about a person's character are not sufficient to sustain a defamation claim for the harm to business reputation.
In terms of that recorded meeting with Ryan, were there just general comments about his character, or were there not more comments regarding his working attitude, about how he worked, his professional attitude?
There were comments. I think the comments at issue were related to excuses that the appellant had provided that were inconsistent for his inability to work overtime. We would also submit that there's evidence in the record that establishes that there was no actual harm to appellant's professional reputation. He testified himself that he was never denied a job because of these statements, that he actually wound up making more money at other construction companies after he was terminated by our client. There's just nothing to support that this actually would have harmed his professional reputation.
Were these comments made prior to his being employed by MCSS?
Yes, they were.
Thank you.
Great, thank you.
And you have 2 minutes.
Thank you, Your Honor. With respect to respondent's argument that Mr. Bola relies on his deposition testimony, that is not a reason for a court to discount that testimony. In fact, in employment discrimination cases or retaliation cases, that's what you have. And that is a factual or credibility determination that the court must make, that a jury must make, and not the court on summary judgment. We talked.
Saying there's never an instance when summary judgment is appropriate?
I don't think there's never an instance, Your Honor, and I think there are cases that support conclusory statements or the lack of statements. An affidavit that says, I win because I win, so the circular nature of that argument. However, there's deposition testimony here, and despite what respondents argue, there's actual other documentary evidence of Mr. Bola's claims.
So what do we do with the since you say documentary evidence, what do we do with the additional evidence that shows us that there is a legitimate reason to terminate him based on his behavior that was, other than him denying that he behaved badly, we have his last, the event that caused his termination was in front of 65 workers who walked out because he was so abusive. So if an employer cannot terminate someone who deserves to be terminated from their estimation, then where are we?
Your Honor, I think that there's another side to that. If a plaintiff can be fired summarily because he's enforcing safety regulations and then complaining when they're not observed.
No, he's fired because of how he does his job, not that he did his job. And if the court finds that that is the case, why is that not an appropriate circumstance for summary judgment?
Because I believe it's not an appropriate finding because the record establishes that the reasons proffered by the respondents are pretextual. As I said, Your Honor,
So if we disagree with that statement, that it was pretextual, you lose.
Your Honor, I don't think that's true because
So yeah, you want to have it both ways.
I don't. What I want is for these determinations to be made by a jury.
But the case law doesn't require that, where there is sufficient basis in the record to show that the termination was not pretextual, but that there was a sound reason for it. But we're not going to debate this, and thank you for your argument.
Thank
have
you
a
very
great
much, Your
day.
Honor. Have a wonderful day.
You too. Beach versus, all right, I know I've said this wrong, so tell me how to say that first name.
Taraji.
Taraji? Taraji, okay. Capital Management. I'm not going to try it again. All right. And you may proceed when you're ready.
Good afternoon, Your Honor. Rolando Acosta for Appellant Bolero and Beach. Your Honor, this appeal is about preserving the integrity of two jury verdicts that rejected defendants' counterclaims after two full trials, the last one taking over 24 days of trial time. The trial court, in our estimation, has no authority to disturb those verdicts. In fact, as Your Honor is quite aware, judges may only set aside jury verdicts when, when it's clear that the verdict is against the weight of the evidence. That is, that there's no valid line of reasoning or permissible inference to support that verdict.
Counsel, let's talk about the faithless servant affirmative defense, right? Is the allegations that make up the faithless servant defense a part of the allegations for the counterclaims, that being the breach of fiduciary duty?
It is, Your Honor. The forfeiture, and this is where part of the mistake that the trial court made, the court conflated a faithlessness doctrine with non-performance under the contract, and they're not all together at all.
Well, it's not non-performance. Is that if the other side can establish that your client was a faithless servant, then they are not required to perform under the contract, and the perform being make payment, right?
No, Your Honor. The faithless servant defense is a doctrine that is basically encompasses a forfeiture principle that permits an employer to withhold or recoup compensation earned during the period of disloyalty. So if I work for a month for an employer and I work my 3 weeks and there are questions with respect to that, my last week of employment, the question is not whether I perform under the contract. I did perform. The question is whether the employer is entitled to an offset or a forfeiture for that week that he's able to prove that I was disloyal.
So essentially, the faithless servant would go more to damages. Is that what you're arguing?
That's right. It's a remedy for damages, not performance, and that's the confusion.
So would since the counterclaims were dismissed and the faithless servant affirmative defense is still pending, if a new jury, let's say that we agree with you and that we should not reinstate the counterclaims, if a new jury were to find that the plaintiffs were faithless servants, wouldn't that somehow have an impact? Wouldn't that be inconsistent with having dismissed the counterclaims?
Right, and the inconsistency will be created by undoing the jury's determination. The jury already determined that there was no disloyalty.
The breach of contract, they didn't resolve that issue, right?
That's right. Your Honor,
So are you suggesting that the verdict that they reached on the counterclaims requires dismissal outright of the contract claim?
Well, the way I would put it, Your Honor, is you're talking about two principles, right? You're talking about a breach of contract claim, which is basically a plain vanilla claim that turns on contract formation and performance, and on which the jury deadlocked 4-2.
Right.
The counterclaims, defendants' counterclaims based on faithless
We're
servant.
trying to figure out,
Yeah.
and I'm sure the both of you, all of you have been doing the same thing. What is the impact, okay, on the verdict, on the verdict on the counterclaims with the faithless servant's defense? What is the impact of those two? Because it seems to me, how would they not be inconsistent? If it goes to trial on the contract claim and they say, yeah, yes, there was a contract, but they were faithless servants, right? How does that jive with the dismissal of the counterclaims?
It doesn't jive, Your Honor. That's our position. Our breach of contract claim stands on its own. And basically, if you look at the verdict sheet that was put together for the jury, the question was about whether there was an oral agreement, right? And that is really the essence of the breach of contract claim.
Counsel, what's the record cite?
Did the parties 2005, I'm sorry, Your Honor.
Sorry.
Let me just read, did the parties 2005 oral agreement provide for a formula-based bonus, as plaintiffs testify, as the evidence was, or a discretionary bonus, as defendants claim?
Right, so you're
Those are
saying
the only issues
that
that
that's the only issue now, is that everybody agrees there was an oral contract, just the question is what were its terms?
Right, but then,
But that's the only thing that you think is going to be tried, if we agree with you and send it
That's
back.
the only thing that should be tried, Your Honor. Juries cannot continue to dismiss counterclaims. Two juries have unanimously
Okay,
dismissed
but so
state
if we
tort
go,
claims.
we go to trial on the contract claim, are you suggesting that the other side cannot put forth their affirmative defense of a faithless servant? Is that what you're arguing?
Well, let me.
I need an answer to that question.
Yes, Your Honor, and the reason is because when you look at the affirmative, when you look at the counterclaims had 5 elements, Your Honor. 3 against Mr. Beach. Did he misrepresent or fail to disclose material information about a private equity investment? Did he conspire with his father to take an unauthorized distribution? And whether he failed to disclose material information bearing on the valuation of this Madagascar oil investment. And then with respect to Mr. Bolero, it's really, did he misappropriate confidential trade secret information? Or did he collect and fabricate evidence, namely his own notes?
So it sounds to me like all of those counterclaims, having been dismissed, really are not dealing with the compensation of Beach and Valero.
That's right.
So then why would the faithless servant affirmative defense not be a viable defense on the breach of contract claim, right? Because the jury has already decided you're not entitled to extra money because of deals you say that they messed up. Okay, I get that argument. But that's separate and apart from, I hired you to do a job for me, and you were a faithless servant, so I shouldn't have to pay you any more compensation. Why are those two not completely separate issues, and that the third trial cannot just resolve those 2 issues, assuming this court agrees with you on the counterclaim dismissals?
Because the faithless servant is only a forfeiture remedy.
Right, and that's what
That's right.
they are suing for their salary, for their earnings, right? And
compensation.
so that is precisely what the faithless servant
Right. And
doctrine
they-
goes to.
That's right. And they were claiming, well, we're entitled to an offset or a forfeiture remedy for the period that you were disloyal. The problem that they have is that the jury, 2 juries now have unanimously held that there's no disloyalty here.
So counsel,
On this one didn't hold that.
well, are you saying they held that, counsel, are you saying that that was held because of the dismissals of those counterclaims vis-à-vis the dismissal of the breach of fiduciary duty?
Yeah,
So because those counterclaims were dismissed, well, not dismissed, but because they weren't, the jury didn't find those counterclaims, that means that we should also preclude the defendant from asserting the faithless servant defense?
yes, and the reason for that is because you're talking about the same factual predicate for it.
Right,
All
but
the
that would
affirmative
be the reason why the judge,
In the affirmative
counsel,
defense,
I'm sorry, but that would be the reason why the judge put back in the counterclaims, because you can't separate, you can't have the defendant not have any defense and separate their defense from the counterclaims that the jury didn't find for.
yeah, but the question is, Your Honor, whether they are inextricably linked, and they're not. And that's the fallacy.
We could talk about, because I've given you double the time,
Okay, thank you. Your
and
Honor.
I'm sure you're going to get double the time too, because this is a,
Sorry, Sally.
no, not at all. So I'm going to just add a couple of minutes already.
Thank you.
Go right ahead.
Thank you so much. May it please the court, Samir Degasen for respondent. And I think the court's questions have really got to the nub of the issue, which is, I think it's conceded essentially from what we just heard that there is interwovenness between these counterclaims and the faithless fiduciary defense. And I think they have to.
And there are, but that doesn't mean that we have to disregard the jury's finding on the counterclaims. It seems to me that they're separated, because what they were seeking to be compensated for is different.
No, so the faithless fiduciary, there's the question of performance, and then there's the question of the faithless fiduciary defense. And the faithless fiduciary defense, and this is, if you look at the jury instructions on this at A.
Counsel, can you give us a record site for, is the jury verdict form that was actually filled out by the jury in the record?
It is, yeah.
Do you happen to know what that is?
Don't have that.
It's such an immense record. I didn't find it.
Yeah, we
so
couldn't find it. None of us.
I can tell you what's in there if
Please continue.
But yeah, I mean, but if you look at the jury instruction at A417, sorry, A4917, all of the predicate acts that underlie the counterclaims, and I think Mr. Costa just conceded that, the same things, the theft of trade secrets, the spoliation, the attempts at unfair competition, all of that, and the misappropriation of funds for Playa, all of that stuff is the same stuff that we said that disentitles you to compensation. So even if you prove your breach claim, you're disentitled to compensation, and that compensation can be a complete forfeiture. And that's our defense. That's our faithless fiduciary affirmative defense.
That's what you're left with, because your counterclaims have been dismissed, or were dismissed and then reinstated by.
Right, and so but the second, this is the key point, the second jury is going to have to assess.
It's the third jury. This case is about to have its 17th birthday.
Well, that's true, but the first, it's strange they mentioned the first case. The first case this court held was infected by serious error and went back, so I don't think that can really count against us.
But it's still a trial that this
It's
system
still a
had
long
to
time, but
absorb.
right, and the question ultimately is but there has to be another trial. There's going to be another trial, and the question is what happens and what at that other trial. And
But in your counterclaims, you are seeking to be compensated, whereas in your faithless servant defense, you are seeking not to have to pay.
yes, but it's the same underlying facts, the same proof the jury is going to have, the exact same things. And so to go to the verdict form does say, essentially, the plaintiffs did not steal trade secrets. Plaintiffs did not, take this money from Playa. So then let's see what happens in the second jury. The second jury, those exact same findings, the jury could come to the opposite conclusion. It could say plaintiffs did do this, and therefore they're disentitled to compensation, and that's the
Should
inconsistency.
they even be allowed to consider the question?
And that I think is it. What is the solution to that inconsistency? And they say preclusion, and I just want to emphasize, and I cannot emphasize this enough, that is completely wrong. Preclusion requires a final judgment, and a final judgment only occurs when all the claims in the case are resolved. And there is no final judgment here. There can be no final judgment here because not all the claims are resolved.
What are you arguing is the, go ahead.
I'm curious whether you contend that there are factual showings that could be made in support of the faithless servant doctrine that are not encompassed or precluded by the jury's verdict on the second jury
The-
trial on the other 6 affirmative counterclaims?
There are some, for example, there's the Regulation M violation that is one of the things that underpins the faithless fiduciary defense. So it's not completely identical, but it would certainly be considering the same proofs, and there'd still be a prospect of inconsistency. And I think the question is, how do you deal with that inconsistency? They say preclusion, but preclusion does not apply until there's a final judgment. Just because I think this point is so important, I'm going to read a little bit from this court's decision in Shaw. The verdict of a jury in a prior action upon the precise point involved in a subsequent action between the same parties does not constitute a bar unless followed by a judgment thereon. Principles of res judicata are inapplicable when, as in this case, the two determinations arise in the same action as opposed to different actions, and because no judgment has been entered in the prior action between the instant parties, the doctrine of res judicata is not applicable.
But we do have a judgment on your counterclaims.
You do not have a judgment on the counterclaims. It has to be a final judgment. You have a jury decision.
Well, there's a verdict, right?
There is a verdict.
And
that's
we
not-
have strong case law that favors upholding jury verdicts, correct?
But it is not. It can within the same case. It cannot have preclusive effect unless it is reduced to a judgment, and it cannot be reduced to a judgment until there's final judgment.
I'm not asking you about preclusive effect. I'm asking you about the case law that holds that we adhere to. We want to adhere to jury verdicts. We want to give full faith to jury verdicts unless there is some basis not to, a legal basis not to. What are you arguing would be the basis for the court to disregard the jury's verdict on the counterclaims?
The fact that it's interwoven, and interwovenness is one of the exceptions to that. I mean, ultimately, faith in
Interwoven in a negligence context. Do we have interwoven in a contract context?
the
Through case law.
The interwovenness doctrine goes back over 100 years, and it is based on the idea, this is what this court said in Arnold versus Arnold in 1930, that a limited retrial is never a matter of right, but always a privilege.
What kind of case was that 100 years ago?
I mean, I think it's a personal injury case, but
Exactly my point.
well, I don't think the nature of the case changes it. I think, well, the question is, the exact question we've been discussing, is there this, the law really abhors inconsistency. It does not want a situation where you could have two juries looking at the same set of facts and drawing opposite conclusions.
At the end of the trial, when the jury did not reach a verdict on the other two counts, was there an argument made that failure to reach a verdict on the remaining claims could cause an inconsistent verdict and ask the court for a remedy with respect to that?
I don't think that the jury was informed of that, but the thing which happens
It's
when
not
you
the jury.
Arguments.
The judge.
You see, because my understanding of the law is that if you receive a verdict that you think has the potential to be inconsistent, you have to bring that to the court's attention so the court can remedy the problem before the jury is disbanded.
But to be clear, there was no inconsistent verdict here. The problem isn't the inconsistent verdict here. The verdict is consistent.
But you were shaking your head over there when I was asking them questions about whether not sending it all back could result in an inconsistent verdict, and you were going like this.
Yes.
Right? So if you agree that indeed sending it back without all of the claims, again, could result in an inconsistent verdict, why was there not a duty for you to make that argument? I'm not saying you personally, whoever tried the case, at the end of the trial when there was a partial verdict? In light of the interwovenness, you needed to get a full verdict.
We did. This is the relief that we saw. This is the post-trial motion. So there was
But by then it was too late because the jury was gone. They couldn't remedy the problem.
They're not supposed to. There's nothing wrong with the jury's verdict here. The jury said
Well, when you're sitting at the trial desk and you hear this verdict come out, right, and you know that you have the faithless servant doctrine as a defense, but they've just found that there's no breach of fiduciary duty, understanding that it's going to go back to a third trial. Doesn't it ring alarm bells that there is this potential that if all of that goes back, right, as it is, that there's going to be an inconsistency?
I don't think the jury could get to this question question.
It's not a question of the, you're missing the point. It's not that the jury had to do something. Counsel had to alert the court that there was a potential problem with taking just a partial verdict on this case where the primary part of the action is interwoven with the second part of the action.
I agree. And the question is, when were we supposed to do that? There was no-
Right, and
there
so
was-
tell me why you think you weren't supposed to make that argument before the jury got disbanded.
because there was nothing wrong with what the jury did, and the jury couldn't remedy it. So just to
So, counsel, I guess the jury could have just found, we don't know what the oral agreement was here. That could have been the result of it. We don't know why they deadlocked on the breach of contract claim, right?
we don't know, but they deadlocked on that. So sorry, we do know that. As in, we
No,
do.
we know
know-
they
yeah, yeah, yeah.
deadlocked.
Sorry, we do.
We don't know why they deadlocked.
We know they deadlocked on just on the whether they had proven the specific terms of this contract, and we know they never reached the affirmative defense. They never reached it. So there's no inconsistency between rejecting counterclaims and then saying we can't reach a determination.
Please make sure you
on-
tell us where this verdict sheet is, because I'm trying to understand how this jury went from the primary action and decided the other claims without deciding the primary action, right? So I'd love to see this verdict sheet. I want to see what the judge's instructions were. Like, don't proceed to the next question until you answer this one, for instance, right? We need to see that verdict sheet. Please make sure you let the court know where in the record that is.
Okay, we want the appellant, so we didn't put
Both of you. I don't care who we
Right,
get it from.
And,
so long as we
and
get
Your
that
Honor, we're happy if one answer here is that we submit some supplementary briefing on this with the verdict sheet and to explain this, we're very happy to do that. So if that's.
I just need to see it. I know what the verdict sheet
Okay.
is and what it should have
Well,
said.
can I make just two final points, one about defamation and one about preclusion?
Sure.
So on this, I do think that the stepping back, the really fundamental thing is they concede, I think, interwovenness or interrelationship, and they say that the solution is preclusion. I really want the court to be clear that preclusion can't apply, and it can't apply even as law of the case. This is what this court said in the Shah case. Law of the case similarly has no application here. That doctrine applies to judicial determinations of law. To state the obvious, a jury verdict is not a judicial determination of law. If you want law of the case, you've got to ask the judge for a finding that no reasonable juror could make that determination. So they're asking for things that they didn't move for below and would violate this court's preclusion doctrines. It's very important that the court doesn't order that. And then one final point on defamation, if I can have 30 seconds. And I'm happy for them to have extra time to address defamation. I just want to.
Go ahead, give away time.
I just want to lay.
Give away, right?
I just
Yeah,
want to.
go ahead.
I just want to lay out so the question with the defamation and the determination of the trial court gets great respect here is whether Gentry connived or assisted in the publication of the libel or was the moving cause or instigator of it. Here's the timeline. Gentry gets the Fortress report on February 9th at roughly 6:30 p.m. Gentry tells Gary, quote, I commissioned the report, quote, you have to work directly with Schuster, his lawyer, to get the report. He then puts Gary in touch with Schuster, he admits that, and that same day, Gary signs an engagement letter with Schuster's firm, and the next day, Schuster sends Gary the report entitled, quote, report Gentry Beach. So if you lay a trail of breadcrumbs to someone, you tell them the existence of something, how to get it, who to get it, the mechanism
That
of
sounds
getting
like
it.
aiding and abetting publication. I don't know, does that exist in defamation law?
Yeah, that's exactly what the
What's your
Shopland v.
best case
Coffee
on that,
case that
counsel?
we cite says, is that if you connive or assist in, which is basically the principle is, if you're the moving cause of it, if you lay out the trail of breadcrumbs, you're essentially doing the publication. It's not the same, you can't basically lead the reporter towards all of the facts, but you don't say it explicitly, and that's not a publication. So the law recognizes that, and the jury and the judge's determination on that is accorded great respect under this court's precedent. Thank you, Your Honor.
So much. All right.
Yeah, no, let me start from the back. On the defamation claim, the jury found that Gentry did not publish the Fortress report and was supported by the trial court. There was testimony by the plaintiff. There was testimony by the principal of Fortress who said, we made a mistake. It was a typographical error. We take responsibility for it, et cetera. On the Shopland v. Coffee, which is a Court of Appeals case going back to 1900, publication requires that the defendant procured, requested, commanded, or induced dissemination. The trial court just came up with this implicit publication theory. There's no way in the law. She just made that up, Your Honor.
Well, your
And
opponent
that's
uses-
based on total
Your
speculation.
opponent uses the terms connived or assisted in publicizing the report.
What she says, Your Honor, total speculation, that Beach must have directed his father to obtain the report. That has no evidentiary record. Plaintiffs deny that, and there's no opposition evidence. The jury was entitled to credit. That's
Well,
the-
according to your adversary, he says that your client laid the breadcrumbs in terms of laying out the timeline to this publication.
That's not supported by the record, Your Honor. The testimony that was elicited, the evidence that exists.
And is
does
that
not
enough? Even if he did that, is that enough?
I don't think it is, particularly under the guise of this implicit publication theory that the court just made up with no case support for it. But let me get back to you, Your Honor. The verdict sheet on page 17 of our main brief, Your Honor, first of all, there were 5 elements that were given by the court. One was the first 3 paragraphs had to do with the breach of contract claim, right? The Gentry Beach and Bolero performed under the employment agreement. The TCM breached the term of the oral bonus agreement with Gentry Beach and Bolero is the second question. The third is the amount of damages sustained by each Beach and Bolero. Then she asked this 4th and 5th paragraph, which clearly tells me that she understands that this faithless servant doctrine.
What's 4? Because I didn't see this. What's 4?
I'm sorry. 4, I'm about to read it, Your Honor. It shows me she understands that 4 is, did either Beach or Bolero, quote, act in a disloyal or dishonest manner in substantial respect sufficient to warrant forfeiture of all or part of his bonus during the employment. And then the 5th one is the amount of the bonus to be deducted. So clearly it's an offset doctrine. It doesn't, that's the confusion that the trial court had, Your Honor. With respect to interwovenness, Your Honor, 2 juries have already found in 2019 and 23, they rejected disloyalty based, all of the disloyalty-based counterclaims. Those determinations, I think, preclude litigation. If you go back to Court of Appeals, Dorada versus New York Century Mutual, collateral estoppel and equitable doctrine is based upon the general notion that a party or one in privity with a party should not be permitted to relitigate an issue decided against it. The jury already, 2 juries have made that determination. We accept the first reversal of this court based on unrelated evidentiary grounds. But the second one, there's absolutely no basis to set it aside. And the court understood that. The only reason that the court did it, well, it's interwoven with the supposed performance element of the contract claim. No, they're not. No, they're not. Defendants managed to confuse the trial court on this issue by basically conflating faithlessness with non-performance. That's not a thing, Your Honor.
Counsel, just one quick question regarding the verdict sheet. In a footnote in your brief, you say that the verdict sheet is sealed, and we only have excerpts, right? So we don't have a full verdict sheet in the record, right?
It is incisive, Your Honor.
Okay.
The verdict sheet is incisive, so.
It's sealed and, okay.
We'll try.
Huh?
It's sealed.
We can access it.
It's not. It's incisive at the trial level.
Yeah, it's sealed at NICEF.
Yeah, because it got sealed.
Okay, thank you. Sorry.
So, I'm sorry, can I ask?
Yeah.
So you only have
I
that
got a
verdict?
few extra minutes because he went on.
I have a question. Because we did not get to see the verdict sheet because, of course, it's sealed. And we may not have access to this verdict sheet, according to what I'm hearing. The court submitted only those 5 questions to the jury, and there was no specific question regarding the affirmative defense of faithless servant?
Well, one thing is clear, Your Honor. They reject.
Phrased that way.
Well, it's number 4, right, of what you just read.
It's no, well, the 4th paragraph is similar to the 4th paragraph of the the paragraph that I just read you. Did either Beach or Bolero act in a disloyal or dishonest manner in substantial respect sufficient to warrant forfeiture of all or part of his bonus during his employment? The jury decided no.
Well, they didn't-
And Your Honor,
There was an answer to that question?
say again?
There was an answer to that question?
Yes, the jury decided against them on the breach of contract.
But we don't have that in the record.
We need the verdict sheet. We absolutely need this verdict sheet.
Well, let me talk to
So
opposing
speak
counsel.
with
and see
counsel
whether we can
and
commit
provide
on
that to the
seal.
court, okay? And I thank you both. We have
Thank you,
gone
Your
on
Honor.
for a very long time, but very live issues.
Right, right.
We will be looking at this deeply,
Thank you, Your Honor.
okay?
It's so crazy that none of them would realize we need to see.
Sebastiano versus Schimmerhorn LLP.
Schimmerhorn. It's crazy.
Okay.
Good afternoon, Your Honors. Brian Isaac. I represent the defendant appellant in this case. As you know from reading our brief, our position is there's no basis for a legal malpractice claim here as a matter of law. And I think the basic issue is lawyers are officers of the court, right? On an appellate level, my adversary doesn't cite a case. I have to cite it if it's against me. I don't think lawyers can be made to make up claims that just don't exist. This building was built for purposes of the code in 1915.
Did we already find that
Yes.
in 2011?
Yes, you said it in the opinion. But I'm going to make this even easier for you, Judge Mendez. I want you to look at 1617 of the record, and I want you to look at paragraph 12. This is not me. This is Elise Dan, the architect, who is claiming that you can have varying dates for code provisions depending on when something's constructed, which I cannot even figure
Also,
out
she
how
was
that works.
plaintiff's witness, right?
Excuse me?
Plaintiff's witness.
Not plaintiff's witness. This is their witness.
I'm sorry, defendant's witness.
Yes, and let me read you what she said. I'm quoting. First sentence. The Woodlawn subway station, which is the end of the line station for the number 4 subway line, was constructed in an initial phase based on construction drawings from 1913 to 1915. Not 1916, not 1918. That's her statement. She does say, I'm going to be fair, the next sentence, she says, the subject stairway was constructed during 1916 and 1917 based on construction drawings from 1916 under a separate, quote, station finish contract. If you go to the next page, I'm sorry, following pages 1619 and 1620, take a look at the construction drawings. They're dated 1915. So my expert, Mr. Rohde, said, look, the code can't work like that because you can't have the situation where you have approved plans, somebody changes something, and then you can't do the work anymore. It just won't work. And it makes sense. How could anyone do that? You couldn't even do the work yourself because if the plans changed, right, if the law changed, you couldn't just continue to do the work. You would have to rebid the work. You'd have to potentially take out the work. It's crazy.
So even if Mr. Silverman, the expert at trial, failed to do this analysis, it didn't matter. That's your argument, right?
It didn't matter at all legally, but I also just want to say one thing, and I was thinking about this, you know, when you prepare for an argument, you always think about things a little differently. Silverman's argument, you rejected. Now, I understand that there's a doctrine in the law. I ought to know. I lost De Rosa. I lost Gaston. I lost Park, all on these situations. You can't have lawyers, architects, or engineers tell judges what the law is. The court tells the court tells us what the law is, and the court tells us what
They're not telling
applies.
us what the law is. They're just telling us when the construction began or when the plans were approved. They're giving us a datum point in time.
Correct.
That's all.
But that date and point of time, Judge Moulton, has to be finite, because if it's not finite, it just doesn't work. So I think what Mr. Silberman said, and it actually makes sense, even though it was rejected in Sebastiano, I agree that was a decision. What he said was there's a difference between construction-related activities under the building code and maintenance. And it makes sense, because the way I read 27-115, what the legislature doesn't want to do is to say, look, you bought this building, it's an 1899 building, we're not going to make you retrograde it because an accident happened in 2017. That's just not fair unless you do construction work, which upgrades it 60%, right, of the value of the building in any 12-month period. But there's a different scenario with regard to maintenance. Maintenance is maintenance. And just because someone complies with a legal mandate and just because a building is code compliant doesn't necessarily mean that that satisfies a common law duty. You said that since Sherman against Lowenstein. So this is just a case that doesn't exist. And if you look at Mr. Mastro's affidavit as well, you'll see that he gave detailed explanation as to why it would be impossible to prove the 27-115 predicate. The only thing you have in opposition, and I know you can do it, I read the third department case, I don't know how you're gonna try the case, but you can do it. You have a situation where my adversary, very good lawyer, very smart, he's the expert. With all due respect, if you can't get an expert and you have to rely on your own lawyer to get an expert, that's really something where the proof is in the pudding. So for all those reasons, we respectfully submit that this was a case that should never have survived summary judgment. The lawyers didn't do anything wrong here. One more thing. This would have all been eliminated if the jury had found on the negligence case, and you know what happened. They found negligence but no proximate cause, probably because of the testimony of Mr. Green to the effect that the plaintiff didn't fall where she was. And in the last paragraph of your decision, you noted that the verdict, I'll stop after, wasn't inconsistent because there were two different standards on a 205E claim. So we're asking for reversal and dismissal of the case. Thanks for listening to me.
Please the court, good afternoon. My name is David Fishman. I think it's important here to look at the context of where we are in this case in terms of the actual motion for summary judgment and the court's decision in the case. And when I first read the court's decision in the case, I was a little puzzled. But then as I kept reading it over and over again, I think I understand what she's talking about here, is that they didn't make out a prima facie case, that their engineer, Mr. Rohde, did not establish any familiarity with the custom and procedure in the early 1900s, right? So that is telling us that he did not give a bona fide qualified opinion based upon the circumstances and the age of the documents, building code, et cetera. So she concluded that
Is there an issue as to when this station was built?
there's an issue, yeah, there is, in terms of what's important in this case, yes, because
There are architectural plans in the record.
there's architectural plans
That were
from
approved.
1915, from 1916. There's an issue about whether a date on an architectural plan, what that actually means in practice in terms of construction, and what the 1916 code means by quote unquote new work. All right. So I think that the court found that based upon the appellant's expert claiming that this was not, that this was in the 1915 code applied, for example, that they didn't establish their burden. They didn't establish a prima facie entitlement to summary judgment.
So-
Likewise, sorry.
So how do we reconcile our decision from 2011 that says that it was built in 1915?
Yeah. First, I would say that the underlying case is not this case here, where we're saying that there was negligence in obtaining the result in that case. And I think that
What difference does it make?
it makes a big difference. Sorry.
Regardless of the nature of the claim, this was a factual determination, right? So what,
If there was a factual determination which was a product of a lack of care, then I would submit to you that that's an issue in this particular case that's in front of us now. And
A lack of care by who?
I don't understand what you mean.
Yeah, I didn't understand your line of reasoning when you say there was.
it's opaque, but there is a line there somewhere.
Okay.
If the law of the case was established on the appeal on the underlying case, and that year was the product of negligence by the law firm, all right? Now, I think that's fair game for me to comment on that and to perhaps show that that was wrong.
In order to show that was wrong, though, you would have to show what it is that the lawyer relied on that they shouldn't have relied on, especially if the lawyer relied on an expert in that area, but was just wrong in the ultimate determination.
Right. At trial, the trial expert Silverman, who was referred to earlier by name, all he talked about was the 1968 code. He didn't mention anything about the plan, the date of construction, the stairway construction, right?
How would we impute that onto the lawyer in terms of malpractice, though? What legal import does it have in that analysis? Because the lawyers rely on experts, right? In areas that require expertise.
They do, but they're not blind passengers in that regard. I think that if an expert comes up with something that doesn't make sense legally, then it's up to the lawyer to try to reconcile that with what the case needs to be proven.
Well, in this context, though, how would a lawyer relying on an expert see that line of reasoning doesn't make sense when everyone here is arguing about when the building was built and what codes apply?
Agreed. But the point here, I think, is that they didn't even go to that issue. All he said was, yeah, it's a violation of the building code as it is today. And that wasn't the relevant question because they didn't establish that the 1968 code could be bootstrapped onto this particular case on a building that was built in the early 1900s.
Okay.
Thank you.
Once again, Your Honor, there's no dispute about that. That's why the lawyer didn't do it. The plans were approved from 1913 to 1915, relying on what the experts said. The lawyer prosecuted a claim that made sense because his expert said, and this is what Mr. Rohde says, you can't have a code provision where you have approved plans, and then after the fact, you tear it down because something changes, or you have to go back and redo it. Moreover, I just wanted to point out one thing relative to this issue about which code applies. Elise Dan, the defendant's witness, in direct contravention of what you said in Sebastiano 1, actually says that the 68 code applies. I'm going to read it word for word. 1627, subdivision C. The sections 27-127 and 27-1.8 of the 1968 building code of the City of New York are applicable to the subject stairway in that it requires that any means of egress safeguard required at the time it was constructed be maintained in good working order. How can my client be guilty of legal malpractice for following the exact edict that his expert just said that I read to you verbatim? Thanks for listening.
Thank you. Capitus Servicing versus Suburban Waste.
May it please the court, Robert Malatak of Windells, Marks, Lane, and Mittendorf, counsel for appellant. We believe that the lower court erred in its application of the OLAF factors, a three-factor test to determine whether or not an agreement is a loan.
Which factor do you think they analyzed wrong?
The one dealing with the reconciliation and the bankruptcy. The court determined that it was a indefinite agreement, so that factor is not in play. In terms of the reconciliation provision, the court found that that provision was effectively illusory, but that is not the case. The paragraph 1, page 1 of the agreement specifically provides that the merchant has a right to a reconciliation if they provide the Capitus with bank statements on a timely basis. Now, what's also very notable
Failure to do that results in a forfeiture.
of that right. So it's
To all future reconciliations.
correct.
Right.
But again, it is a right. It's not a discretionary obligation on Capitus's part. If they provide the monthly financial statements in a timely fashion, they have that right to the reconciliation. Now, notably, the lower court expressed skepticism regarding this provision, but more importantly, the defendants did not. In the statement, in their counterstatement of material facts, it's at the 153 of our record. The defendants admit the following. Defendants never made a request for reconciliation, but their right to do so was evident on page 1 of the agreement, and defendants were aware of how to reach plaintiff to communicate. That ends the issue. What the court did by suggesting that that the contract was unclear about the right of reconciliation, et cetera, was supplant its own skepticism improperly where there was none, and wrote out the clear and unambiguous reconciliation provision. Now, there is what's called a discretionary adjustment provision. Immediately under the reconciliation provision I just discussed, there's a discretionary separate provision, separate and distinct, which says that if the merchant makes a request to have any amount changed, the Capitus can consider that separate and distinct. There are cases that are consistent with this analysis that it's a separate and distinct provision. Now, when
So you're saying that's separate and distinct from the reconciliation?
Correct. And I'll give you an example of how that could come into play. So
Why isn't it part and parcel of the reconciliation?
Because it's not, and if it was,
Well, that's it.
but it's two separate provisions, and if you collapse,
Just because you put one, you change a paragraph doesn't mean that it's separate if you're still talking about the same thing.
it's not the same concept, though.
Oh, okay.
Maybe I wasn't clear on that. The reconciliation, in a reconciliation, the merchant has the right to have Capitus compare the daily cash receipts to ensure that those daily cash receipts meet that 5% threshold. If it doesn't, they would be entitled to a debit or a credit.
Okay.
But separately, there's a discretionary provision that says that any amount can be changed upon asking and if Capitus so agrees. Now, a situation like that could come up where, let's say, the original 5% of receipts is too onerous for the merchant at any point in time. They come to the Capitus and say, it's too onerous, my business can't support this. Capitus has the ability, but not the obligation to adjust that. Similarly,
Or if they say you didn't figure this out properly, go back. You're cheating me X dollars. You're not giving me the proper credit. So that could be another circumstance, no?
yeah, or if they have, let's say, a big capital expenditure in the following month, that they're not going to be able to meet that threshold requirement of 5%. They could ask for a relief. But that has nothing to do with the reconciliation, and there's court cases that we've cited that shows that those are two separate obligations and rights. I'll switch over quickly to the bankruptcy because that was another key issue. So first and foremost, the fact that there's some recourse when there's a bankruptcy filing does not rise to the level of the OLAF standard, which is that in order for it to be a loan, there has to be a guaranteed repayment under all circumstances.
So if you can go after the guarantors, and if filing a bankruptcy is an automatic default under the provisions here, I don't understand your argument.
Okay, there's 3 sections that the court needs to focus on. Section 1.1, there are events of default.
Counsel, you're out of time, so if you could answer the question I just asked you, that would be easier than trying to go over your whole argument all over again.
A bankruptcy is not an event of default under 1.1 that triggers the full and immediate payment of all amounts due. The only thing a bankruptcy does is give the does a couple things. It gives the Capitus the right to pursue the guarantee, but unless there's a bad act under 1.11, we can't pursue it to the full extent of the amount that's due and owing. In terms of any confession of judgment, this is not like OLIF. The only thing a bankruptcy filing does without the bad acts under 1.11 is permit Capitus to receive the confession of judgment. It can't enter the confession of judgment, and it can't enforce the confession of judgment until there are bad acts under 1.11.
Thank you.
Thank you. Good afternoon, Your Honor. Stephen Siva on behalf of Respondent. I won't be too long, but I do want to address the reconciliation provision. The plain language is the funder, Capitus, in this situation, may, not must, but may, in their sole discretion, adjust the amount that's to be pulled daily or weekly. And it should work with both ways, because if receivables increase, they should get 5% of those increase, and the amount that you pay will be higher. You'll pay off the total amount quicker. It's supposed to work both ways. But here, it's not a right. It's completely discretionary.
Counsel, there's a lot of lower court precedent that goes to the contrary. You know, why should we not find that persuasive?
I think that there is a lot of precedent, and we're swimming against all of that. But I think that Judge Frank's ruling is correct, and I think that we're not asking for a rebuke of merchant cash advance agreements. There are plenty of circumstances where these agreements make sense, but these agreements have also proliferated over the past few years, and they've really been bogging down the courts. And we need clarity on both sides. What is a true merchant cash advance agreement? Has the transfer of risk actually been transferred? Because to me here, especially with this agreement, Capitus gets the benefit of a regular term loan, actually more protections than a term loan would get. They securitized it with a UCC financing. They've mitigated their risk to a certain extent through personal guarantees. They've also, the confession of judgment was delivered upon the execution of the agreement. All of these things together, and the lack of a real meaningful reconciliation provision altogether show that the transfer of risk was not transferred to the extent that justifies the increased rate of return, because that's what this all is about. Rate of return should be correlated to risk. And here the risk is just not there. It's been mitigated. Thank you.
Thank you.
Mitigation of risk does not make this alone. Again, Olaf says the guiding principle is whether the plaintiff is entitled to repayment under all circumstances. Here, just because there's a bankruptcy filing, the court respectfully must look at 1.11. It's only if there are bad acts, which would then require the full and immediate payment. The bad acts that they committed, for example, they stacked us, meaning that they took out additional financing without our consent. They also—
Is that an issue of fact, though? I mean, there was an appendix to the agreement that specified other transactions that could affect this transaction.
No, that's not an issue of fact.
Okay.
And,
but what about the appendix? Am I making that up? I mean, there was an appendix, right?
There is an appendix, but that does not permit them to take additional finance. And what they did was they sold the same and leaned up. Sorry.
The same receivables.
Oh boy, can't get a word out. It's not impressive, right? Sorry. They leaned up and sold the same receivables that we already owned, and they froze the account, and there was plenty of money to pay us. It's only in those circumstances that we're entitled to full payment. simply a bankruptcy without those additional bad acts under 1.11, we are left with something much less than full payment. And that's why if we would have pursued a guarantee without those bad acts, we would only get something much less than what we were entitled to. And thank you, Judge. Thank you.
Batista versus Bulgos.
Well, we already
did that one.
Oh, that's right. I didn't scratch it off my list.
We can do it.
No. People versus Anthony Henry. My apologies, guys.
I'm like, what? They're back.
You may proceed.
Thank you, Your Honor. May it please the court, my name is Paul Wiener, appearing for appellant Anthony Henry. From June 22nd, 2021, when the court decided the omnibus motion, until April 8th, 2022, Mr. Henry's case came to a complete halt because the prosecution was seeking to get comparative DNA evidence.
Didn't the court also acknowledge that ACME was having a hard time? I'm sorry, I'm talking too fast. Didn't the court itself acknowledge that ACME was having a hard time during this COVID period, and that ACME was prioritizing people who were in custody as opposed to people like your client who were in liberty?
Well, but the thing is, Your Honor, that is true, but on February 14, 2022, which is almost 8 months after the case came to the complete halt, the prosecution suddenly announced that this evidence was not necessary for their case.
Did they say that the evidence was not necessary, or they said that they were ready to proceed without the evidence?
They actually said that the evidence was not necessary for their case.
Yeah, you quote that in your brief.
That's quoted in the brief. And not only that, but that was completely consistent with what they had been saying since the beginning of the case. Right after Mr. Henry's arrest, the prosecution stated over and over again that in their view, the evidence was overwhelming, and they listed all of these various reasons. And then on February 14, 2028, when the case has been languishing for almost 8 months, they suddenly say, "Oh, we don't need this evidence; it's not necessary."
So what are we to make of the defendant's declining proceeding to trial when the prosecutor said, "We're ready to try the case without the DNA evidence," and actually wanting the DNA evidence?
But he never said that he was waiting. That they wanted the DNA evidence. That they are on February 14, 2022. It's true that the judge said, "Are you ready to proceed immediately?" And counsel said no, but he certainly didn't say no. I want to wait, indefinitely.
How many more times did the defendant ask for the matter to be adjourned?
I don't think the defendant ever asked for it to be adjourned after.
Several times.
After that.
After that, yes.
No, I don't think so. I think it was then scheduled for April something, and that's when. That's my recollection.
But you do concede that some of the delay was occasioned by defense counsel not putting in responses to motions on time, right?
It was the delay up until June 22nd, 2021.
Is there an answer to that question?
Yes, that's when the court decided the omnibus motion. After that, you're correct, Your Honor, that defense counsel asked for a 2-week delay to respond to the buccal swab request. But that, again, all that has to do with was the DA's effort to obtain.
So when do you think that
DNA evidence.
that the charging time, because clearly the defendant's filing of an omnibus motion is excludable time, right? And motion practice and the time for the court to decide the motion is excludable time. So tell me what date this court should say, this is the magic date when we should start charging time.
I would say, in addition to the 29 days which are conceded, June 22nd, 2021, which is when the omnibus motion was decided, until April 8th, 2022, when the
Wait a minute.
DA...
On June 22nd, the court issued its decision on the motion, allowing defendant additional time to respond. Then the court adjourned it to September 21st. So that's excludable.
But everything...
No. The people's motion allowing defendant additional time to respond, that is excludable.
But that was in response to their seeking the buccal swab, which has to do
But
with.
it's still motion practice. It doesn't.
But we're saying it's motion practice that just isn't necessary, and it's not material under this court's decision, under the way they've interpreted 4G1, their evidence has to be needed or necessary to be material. And there was this whole delay after
So the
June
court
22nd.
granted the defendants, the court granted the people's request for the DNA swab on September 17th. And on September 21st, they weren't able to do the swab because there wasn't people available, police officers available to do the test because of the UN General Assembly. And it got adjourned for that to happen, and for the testing and the issue of the report, and it got adjourned to December 8th. So you're saying that time should be included too?
I'm saying, and anything after September 22nd, 2021, which is when they decided the omnibus motion, the next 10 months all had to do with the prosecution's efforts to obtain this comparative DNA evidence, which they then conceded 8 months later wasn't necessary.
But at that point, when they conceded it wasn't necessary, the people said they would proceed without it, and defendant did not want to. And then the case was adjourned that occurred on February 14th, and it was adjourned to April 4th, 2022. So are you claiming that shouldn't be counted against the defendant?
Well, I think even if you exclude that, I don't think that matters, because from June 22nd to February, you're way over 181 days.
But
I don't think that's
assuming that we agree with you. So if
Assuming
we
you
take
agree
out
with-
dates,
but
I'm still talking.
sorry, Arna, I apologize.
So if we remove and exclude dates that were legitimate motion practice, I understand what you're saying. Later they decide we really don't need this, so we should exclude the entire time. I don't know any case that says that, but you'll have time on rebuttal.
Thank you.
Good afternoon, Your Honors. May it please the court, Russell Spivak for the people.
So, counsel, what I hear your adversary arguing is because at a later time, the people indicated that this was not evidence that they needed and that they would be willing to go forward, that any time attributable to this motion or at obtaining the DNA was chargeable because you later, at a later date, said that you didn't need it to prove your case. Is that what happened here?
I understand that to be my adversary's position, Your Honor, but I don't think that that passes muster under this court's opinion in Acosta, which says that the defendant can't use any opposition to the people's motions practice as both a sword and a shield. The defendant said—
Yes, but the people also can't order tests that they don't need, that they have no intention of using, and keep somebody from having their day in court either. And we have had cases that have so held.
Understood, Your Honor, and of course, I don't mean to argue with the premise, but here I think the facts of that are different. Under matter of Abe A, I believe is the Court of Appeals in 1982, it doesn't say that the evidence must be necessary, it just means that it must be material. And I don't think that there's a real dispute that whether or not an individual's DNA—
What record did the people make at that time when they said that they would be ready to proceed without the DNA? Did they make a record that reflected that the DNA was not material to moving forward, and that's why they were ready to move forward?
No, Your Honor, I think the context is important. At that juncture, there had already been multiple delays, and the trial court, recognizing that the defendant has speedy trial rights and wanting to safeguard those, was somewhat lamenting, and I think as the people put it in our brief, had to make a hard choice. It's understandable that, of course, DNA might certainly smooth over some of the concerns that the people might have had, but to say that it wasn't material, to say that it wasn't bearing on whether or not whether or not the people would be able to prove the crime, I think is very much far afield from the truth. Right at the beginning of the case, there was a—
You understand, though, that if you make a record that says 8 months later, 9 months later, oh, we're ready to go, we don't need the DNA, that undercuts the argument of 3030 AG. that this information was material for your case, to prove your case?
I don't agree with that, Your Honor, because I think we're conflating necessary and material. If the legislature wanted the the exceptional circumstances exception to be for only necessary evidence, one, that would be a very difficult, from an administrative perspective, it would be difficult to determine what is necessary from a factual perspective.
What's necessary is what's material to proving your case.
Sure, but I think that necessary is a much higher bar than the legislature put it at material. There was no dispute before that the evidence was material. That wasn't disputed at the motion for a buccal swab. That also wasn't disputed by the defendant at the 3030 stage below. It was sort of common sense to think that whether someone is touching a gun bears on the fact, is relevant to the fact, or speaks to whether or not he or she possesses the gun.
Counsel, do we even get to this? Because we haven't talked about the appeal waiver yet. The written waiver contained an explicit waiver of 3030 rights, right?
Correct, Your Honor. I appreciate you bringing that up. I was about to pivot there myself.
Well, I figured
Yes.
the other side we want to hear them too about it.
Of course.
Was it knowing, intelligent, and the third thing?
Unquestionably.
Voluntary. Thank you.
Yes, Your Honor. I think without question that the oral colloquy was in and of itself sufficient. Justice Farber did, I think, an exhaustive job going through, even when there was a dispute about, the defendant might not have understood the nature of the question. It said, please take a moment, make sure to confer with counsel, make sure that you understand what's going on. Asked repeatedly whether or not the defendant had in fact read the written waiver, asked to make sure that the defendant had understood it, made sure that he conferred with counsel that there were any questions, and asked to defendant, do you have any questions? And after being sufficiently any concerns would have been assuaged, then they moved forward with the plea proceeding. And to Your Honor's point, certainly says in the written waiver that statutory 3030 speedy trial concerns were waived.
Okay, thank you.
Thank you.
I'm going to give you the time he left over.
I'll be very brief, Your Honor. I just want to say, my adversary is arguing that this materiality standard is just whether it's somehow in some way relevant. This court, on page 3 of my reply brief, I've listed, I believe, 7 cases where this and other appellate courts have talked about it in terms of being needed and necessary. I've actually used that language, I believe, necessary, and that's exactly what the DA said here. 8 months after the case had been languaging, that it wasn't necessary, and it was completely consistent with what they had been saying earlier. Just briefly, in terms of the appeal waiver, just a couple things. The court never told Mr. Henry that he was giving up his speedy trial argument. And this is significant because that was a hotly litigated issue. In addition, the court specifically told him that he was ceding other issues. For example, that he would not be allowed to argue that his sentence
That was in the oral colloquy, of course, but the written waiver does specify that you're giving up your 3030 rights, correct?
The written waiver said it, but then the court didn't say it, and the court told him that he was ceding other issues, namely excessive sentence. And the court also told him, I think this was probably very confusing to a lay person, that he retained the right to challenge the jurisdiction of the court. In addition, it completely misinformed him about the fact that he was, it told him that he was going to be giving up his right to have appellate counsel assigned, which was wrong. So I don't think it cured what the court did. Thank you so much.
Thank you so much.
Thank you so much, Your Honor.
We go Park Lender versus Golian. You may proceed.
Good afternoon. Greg Zucker of Westman Ball on behalf of Appellant Dr. Joseph Golian. Thank you for this opportunity. A material part of this loan was that my client agreed to only be responsible for $1 million in principal. That was the deal. That's why the loan documents provide that if there was going to be a payment or if there's going to be sales proceeds, it had to be applied first to interest and then principal.
Where does the loan document actually require that?
So, Judge, if you look at page 51 of the record, which is the limited guarantee, that's section 4, which expressly provides that the principal is limited to $1 million. If you look at the note,
In terms of Giving priority to interest or principal under the guarantees. You saying that's the provision?
No, if you look at page 38 and 39 of the note, I'm looking at page 39 in the third full paragraph. Each of said payments shall be applied first to the payment of accrued interest on this note and the balance thereof to the reduction of the unpaid principal balance of this note. That's page 39 of the note. If you look at the mortgage, which is page 90.
Does that apply as well to the guarantee?
Yes, because the documents have to be read in a whole. So if you're going to give meaning to the guarantee, which is the
No,
$1
the
million.
guarantee can have different terms. The guarantee can have different terms than the underlying note, and unless there is some kind of language incorporating the note, then the guarantee stands on its own.
I think, Judge Manzanet, I think they all work in unison. I'll just show you the provision right now. So I mentioned the note. The mortgage says that if there's a sales proceeds, it gets paid costs and expenses together with interest.
But the question is, does the guarantee say that it incorporates all the terms of the note?
Then yes, it does. So if you look at page 53, the heart of their argument is that we waived our rights to an application. That's what this case is about.
Counsel, my colleague just made a statement seeking clarification from you, and you shifted to something else.
I'm going to read the provision that says
Okay.
exactly what it said. So page 53 of the note, it says that we waived any defense to any manner of the application of any funds relieved by by Banco to guaranteed obligations with a capital G and O. That refers to this mortgage, this note. I just read the note. The note says it goes first to interest and then to principal, and then it says or any other obligation. So what that means is that if there's going to be an application of proceeds to either this obligation, this note which I read, or some other property, then this applies.
But with what you just read, didn't that essentially waive any defenses? Meaning you can't assert any defenses at this point.
Judge, the defense that I waived is that if I'm a real estate owner and I have multiple properties with the bank, based upon their form document, they could take proceeds and apply it to this loan at Rejo Park or another loan at 555 Main Street. That's what that says. They wrote the document. It's their form. It says if there's money that comes in, they have the right, and I waive my right, to apply that money to either this loan, which is the guaranteed obligation, a capital G and O. If you look at the first page of the guarantee, page 50, it defines it as pursuant to the note, the mortgage, or the other loan documents.
Your reading of section 10 at page 52 of the record, your reading of that suggests that what the guarantor is waiving is very limited. But in fact, section 10 begins by saying guarantor hereby waives any and all defenses to the performance by guarantor of its duties and obligations under this guarantee, including any defense based on the following, so that what follows doesn't limit it, but is just inclusive.
The guarantor can't be responsible for more than the borrower. The borrower's documents are what governs, which is the note and the mortgage, the loan documents. So if the obligation under the loan documents was that you first pay the money towards interest and then it goes towards principal, that made sense because that was the benefit of my bargain, Judge, because I was only responsible for $1 million in principal. So
Where
when you
does
read
it say
everything,
that? But, I'm sorry, go ahead. Yeah.
When
Yeah,
you say
never
it
mind, go ahead.
You got it.
but I think it's important because if you take their reading of that paragraph, and let's stay on that section 8 on page 53, what they're essentially saying is you don't read the sentence the way it's written. The way you read it is,
Really?
yeah, you say
Really?
Usually we read things
You
as they're
don't
written.
read the sentence the way it's written.
their argument is it says
That I've never heard, in 16 years, that's the first time I've heard that argument.
Judge, the argument they're saying is the sentence ends after.
You're
guaranteed
bound by the four corners of the writing.
Right, exactly.
And if it's clear, it's clear. You waive any and all defenses. That seems pretty clear to me.
But the defenses that I'm waiving in paragraph 8 apply to whether or not they're going to apply the money to the guaranteed obligations, which is this
Does it
one.
say that?
I think it does because
No, it doesn't. It has very general language. You want us to read that interpretation into it. And that's your argument.
And in fact, if you read paragraph 8 in context, what it means is that you're waiving all defenses, including defenses based on paragraph 8, any manner of application of any funds received by Banco to guaranteed obligations or any other obligation. So they're waiving that defense completely in paragraph 8. You're reading it backwards, as I see it.
And you can respond to that on your rebuttal time. You may proceed.
May it please the court, my name is Robert Marks on behalf of plaintiff respondent Rego Park Lender. And I think, you know, your honors have hit the nail on the head, so to speak. The critical language is any manner of application, right? Let me make sure I get this correct. Any manner of application of any funds received. It does not say whether Rego Park Lender applies it to this debt or a different debt, which would be, I think, is my opposition's reading of that clause. This is exactly what they're complaining about. The manner in which my client applied the sale credit bid to the amounts outstanding. It applied it first to principal and gave effect to the limited guarantee to the extent that they're only liable for $1 million in principal, and then to interest. That is the manner of application, and they waived that defense. And even if it's not considered a waiver, I believe it is the only fair way to read the note, the mortgage, and the guarantee altogether. And I would certainly push back on the idea that the note controls and states that interest must be paid first. The said payments, read in comparison in context with the note, is monthly payments of interest and principal.
That means when the payments are being made on time.
Correct.
And there's no default.
Correct.
Right? So that application applies when everyone is doing what they said they were supposed to do.
Exactly, Your Honor. And the mortgage deals with when there's a sale of the collateral, and it says first to costs and expenses of the mortgage and sale, and second to principal and interest. And it doesn't distinguish principal first, then interest, or interest first, then principal. So then you look to the guarantee, and it says any manner of application. If I can touch very briefly on the RPAPL 1371 issue as well. And I would submit to the court that the plain reading of that section says that a
It only
deficiency...
applies to foreclosure actions, not to bankruptcy sale.
Exactly, Your Honor. The judgment of foreclosure was never entered. There was no order confirming the sale. Therefore, we didn't have to make a motion for a deficiency judgment within 90 days. And I would point one final thing out to Your Honors, because it wasn't in my brief. On page 274 of the record, which was the order confirming the bankruptcy sale, there's actually a paragraph where the parties contemplated a future guarantee enforcement action, which is the action before, you know, this court as well. So if there's anything further, Judge, but I think, you know, you have it under control.
Thank you.
Thank you.
You have 1 minute.
Judge, I would just say that in the note itself, which they drafted, the only place where it talks about allocation is that one page, which I read. The first page talks about interest and payment. The second page talks about the allocation.
We're not talking about the note, we're talking about the guarantee.
But they're all read together. They have to be read together. They're one document. That's
What about the mortgage?
the mortgage. The mortgage provides that upon a sale, then the order of the waterfall is that first it goes to costs and expenses together with default interest. But then, yes, Judge, it says in 2, as per the note. And our position is the note provides that it's interest and then principal. You want me to cite the record for that?
No,
I have it,
we
96.
With respect to the RIP Apple 1371, I understand what you said, that the foreclosure didn't happen, the sale didn't happen within the foreclosure. But what's different here is that there was a pending foreclosure. And there is.
Doesn't matter. We have to follow the statute as written. And the statute only applies to foreclosure actions, not sales that occurred during a bankruptcy. But
If I could just be heard on that one point, and then I'll stop.
you have 20 seconds.
Okay. The cases that we cited stand for the proposition that when there's a bankruptcy, the proper procedure is to seek relief from that stay, to proceed with the foreclosure, and continue with the deficiency judgment. The only case that they cite to the contrary is a Connecticut case that doesn't cite New York law.
Thank you.
Thank you.
Hamilton versus Premier Home Health.
Good afternoon, Your Honors. May it please the Court. Jenna Firestein of Galar 11, Ryder and Rogers. LLP, for the appellant, Premier Home Healthcare Services, Inc. This is a case involving an alleged unwitnessed fall. The plaintiff testified unequivocally that she did not witness it, that she only, quote unquote, knows that it happened because, according to the plaintiff, the home health aide that was employed by my client, Ms. Diallo, told plaintiff over the phone that it happened.
Shortly after it occurred, right?
That's what the plaintiff says. Yes, immediately after she
So isn't
allegedly
there then a
occurred.
question of fact whether that's
So
not hearsay because it's so close to the excited event?
it's not, well, not that close, because she said that she didn't even see the fall. According to the plaintiff, Diallo told her she did not
didn't
witness.
see the fall. You're talking about the daughter?
No, I'm talking about the aide. Neither plaintiff
Well,
nor the aide.
except that we have a hospital record.
That was misstated, Your Honor.
Counsel, can I finish
Sorry.
my statement?
Of course, Your Honor, I'm sorry.
Okay. There is a hospital record with extreme detail about her falling and hitting her head, right? And that came from your client's employee. So it seems to me that there's an issue about whether she saw or didn't see.
Your Honor, if I may?
Yes?
I apologize for interrupting, Your
That's
Honor.
okay.
That record does not say that. And I can pull up the record site, Your Honor, just give me one moment. But that record, the Montefiore records, that's regarding a fall that the plaintiff said, she testified, that is not the fall that she's alleging is at issue in this case. And the aide, according to that record, it clearly says that she denied, the plaintiff's alleging that the decedent hit her head in the alleged fall in this case.
These are the Montefiore.
The Montefiore records, I'm sorry, I was gonna get the record site. She's alleging that the fall at issue in this case is one in which the decedent hit her head.
All right,
The fall
but
that's referenced in
you
the
know what?
records, the date
Before
says.
we even get there,
The site, I'm sorry.
how did you establish your prima facie burden?
We established our
Because I don't see it. So tell me, how did you find it? How did you assert it and establish it?
Under Soto, which this court decided in 2009, as we said in the papers, there's a carbon copy of this case.
No, it's not carbon copy, but go ahead.
The reason why I say that, Your Honor, is because in that case, the only evidence, and because again, the Montefiore records, I have to get the site, I apologize, the record page. They don't say that she believes she hit her head. That's a misstatement by counsel for the plaintiff and by appellate counsel for the plaintiff and by plaintiff's expert. It does not, it very clearly says, denies that she hit her head. This was a fall in which the aide did witness, and it was reported and she was brought in immediately.
It
This
might
is a
be
different.
record 1673.
That sounds, yes, Your Honor, I'm sorry.
That's okay.
That sounds correct. And there, like, we have it also annexed, it was included in our motion papers too. I blew up a screenshot of it. It very clearly is the word denies, not believes. But counsel has continued to misstate it without addressing the fact that it very.
I looked at it may be that way, but couldn't it also be the word Diallo, which is the name of the home health care aide?
I don't believe so, Your Honor. The way that I'm looking at that word, it is D-E-N-I-E-S. I don't see an L in there.
So the record at 1512, where it says, found 19-year-old dementia patient, alert and oriented, complaint of head patient, home health aide, states plaintiff patient fell and hit right side of forehead on floor. At 1512, I'm reading from the document. Who would the home health aide be?
Other than Ms. Diallo.
I'm not saying that that was or wasn't Ms. Diallo. That's not the issue. The issue here is that the fall that's alleged in this case is one that the plaintiff.
This is the intake record from this day. So, and he just read from.
Oh, I'm sorry, Your Honor. The record that okay, so that record is one where the plaintiff is saying that, not the home health aide. That was my reading of that.
But this one says home health aide states patient fell.
And if the plaintiff said it, then there is evidence in the record.
But the plaintiff testified unequivocally that the fall that she's claiming in which the.
When you say plaintiff, you mean the daughter?
Yes, I'm sorry, the
Okay.
daughter, Your Honor. And also, I want to add, So that, Your Honor, I'm sorry.
1512.
What, 1512, what, does it have the date on that record?
All right, you're out of time. We have your arguments. We've gone through this record, trust me.
Oh, yeah.
People versus Brian Thompson. May proceed.
Good afternoon, Your Honors. Elizabeth Batkin from the Legal Aid Society for Brian Thompson. Brian Thompson is a schizophrenic man who is spending 9 years in prison for a crime he committed while experiencing psychotic delusions of war on the streets of New York City. We're asking...
Counsel, what I'd like you to address is whether his psychotic delusions were brought about by any actions of his own. And if so, how that should affect our thinking about this.
So I think there's some ambiguity about the exact cause of the psychotic delusion. The psychologist who examined him did say that he committed the crime under the influence of a psychotic delusion. What she couldn't say for sure was whether it was because of a reaction to K2 or else an exacerbation of his schizophrenia from the K2. But I think that this court's decision in People versus Sparks...
And we know that in the mental health industry and treating a patient with schizophrenia or any psychotic type disorder, they are told that they must not mix any drugs with their medication because it renders their medication ineffective and could lead to their decompensation. So, I mean, that is like just standard protocol in dealing with patients who have to take psychotic medication, correct?
Yes, Your Honor, and Mr. Thompson had been working on addressing his substance abuse disorder. One thing that we need to consider is that this did happen in the peak of the pandemic.
So why shouldn't we consider the fact that he took K2 and didn't take his meds as a voluntary act on his part, which affected his becoming psychotic?
I think that to the extent that it adds culpability to Mr. Thompson, it still does not justify a 9-year prison sentence, and we're asking only for...
It does also make this case distinguishable from Sparks, right? Because I was on Sparks in the dissent.
Mm-hmm.
It makes the facts distinguishable.
I think what the important thing to draw from Sparks is this court's opinion that deterrence cannot be accomplished.
Well, the question that I had for you was about distinguishing the facts here from the facts in Sparks. In Sparks, no, go ahead.
No, you go ahead.
In Sparks, there wasn't a taking of drugs. There was no indication of that, right?
No, there was no indication of that in Sparks. I think that, you know, both in Sparks and in Ray's, there was a question about why the defendants weren't on their medication, which is true here. So I think there's always perhaps a question of responsibility that we can attribute to a defendant who is experiencing a mental health crisis.
And in Sparks, it was a singular sort of criminal event versus what we have here, a series of events throughout an afternoon, right?
That happened, from my understanding, over the course of one continuous psychotic event. But I think the important thing to draw from Sparks is this idea that punishment for a person operating under delusions is not just. And that's a direct quote from Sparks. And the question for this court now is whether 9 years of prison is necessary or just for Mr. Thompson, and it isn't. A slightly shorter sentence of 7 years will sufficiently punish him and will accomplish all of the rehabilitation that can be accomplished in the punitive setting of prison.
How much time does he have in?
He has been in since, I believe, 2021, and his maximum expiration date is now 2029. But I'd also point out that prison can exacerbate mental illness, and I think what's best for Mr. Thompson, and frankly, for the community to protect them from Mr. Thompson, is for him to get the treatment that he needs, the medication that he needs, and he can...
K2 exacerbates mental health illness, right? As well.
Yeah.
Yes, Your Honor. But I think that what's needed now is for him to be able to address his substance abuse disorder as well as his severe psychiatric illness in the more therapeutic setting of the community. And I would also point out that he will be on supervision, post-release supervision, for 5 years, even after his release, which is an appropriate place for him to be addressing those problems. Yes, Your Honor.
So before Narcotics Anonymous meetings were interrupted during the pandemic, had he been staying off of drugs other than his prescribed drugs?
I think that the record suggests yes, and he had been voluntarily seeking out that treatment. He had spent times in outpatient programs as well.
What information do we have in the record that he was not using K2 while he was in the substance abuse program?
We don't have that affirmatively in the record, Your Honor, but I'd also point out that he had no reason to think that taking K2 would cause an episode of this intensity, even if he had known he shouldn't take it. He'd never committed a crime of this nature before. He had never committed a crime that had been punished by significant prison time. He had never committed a violent felony. We do ask for a reduction. Thank you, Your Honors.
Thank you. You may proceed.
Good afternoon, Your Honors. Hunter Barron for the people. I did want to start with the sentencing judge's remarks below in the record, where she explained why she felt this sentence was justified, and she explained that this wasn't a case with just one victim.
But you understand that we don't have to defer to what the sentencing judge indicates, right?
Of course, Your Honor. But I just think it's important to explain the thought that went behind this sentence.
I get it, but as your adversary pointed out, this was a 25-minute psychotic episode. It wasn't like he went on a crime spree throughout the night, like, let me hit you here, and then he goes another couple of blocks, hits over there. It was a continuous, right? He was psychotic.
Sure, sure, Your Honor. I would point out that there was a couple-hour gap between the final police crash into the police car, and kind of the conduct. But I understand what you're saying.
Yeah.
I think here the important thing to recognize is that he had chosen to be off his medication at this time.
But that's what I'm troubled about, is how,
Sure.
for someone who's schizophrenic, whose treatment is interrupted by the pandemic and other things, what does it mean to say he chose to be off his medication? Is that a meaningful statement?
Sure, I understand that, Your Honor. There is a note in the record that his Narcotics Anonymous meetings were interrupted by the pandemic when it first started. However, there's nothing in the record to suggest that he continued not to be able to seek substance abuse treatment for the entire, would have been 9 or 10 months.
So we don't know whether by the 2021, whether he was still not able to go to
Narcotics Anonymous, that's correct.
Whether virtually or not, we just don't know. It's not in the record.
It's not in the record. I would point out, Your Honors, though, that this court has addressed excessive sentence claims, and I understand every case is different, but this court has addressed excessive sentence claims involving voluntary intoxication and drug-induced psychosis. Davenport, Torres, Gonzalez, we cite those cases on our brief, and in those cases, the excessive sentence claims were rejected. And I did also want to point out, Your Honor, that responding to my adversary's note about being in the community, Mr. Thompson was in the community when he committed these attacks. He chose to be off his medication, and he chose to take this known dangerous drug, K2, that is known to cause, or that one of its side effects is causing these sort of delusions or violent behavior.
I mean, the question, though, is you keep saying he chose, right?
Yes, Your Honor.
The fact that he may have been off his medication and took narcotics, does that equate to this being a just sentence? Does that mean that there's no basis for a reduction, or that this sentence is not excessive?
I think it's appropriate, Your Honor, to recognize in the context of what was happening here, this is a 15-count indictment. His sentencing exposure was huge, going up to the statutory cap of 50 years. And just on the charge he pled guilty to, the range was from 5 to 25 years, and he received a sentence on the lower end of that range. And it was in the record that the sentencing judge, in arriving at this sentence, had already considered the issues that were raised by the defense, including his substance abuse and mental health issues. And so a reduction by this court would ultimately mean reducing his sentence further by the same factors that had already been considered in already arriving at this sentence.
Which we have the jurisdiction to do.
Of course. I'm not disputing that, Your Honor, of course. But I just want to point out the thought that went behind this plea below, and ultimately the sentence that the defendant agreed to here. So unless Your Honors have further questions or answer questions about the record that I can answer. Thank you, Your Honors.
I'll give you his leftover time.
Thank you, Your Honor. I think that we can absolutely grant that Mr. Thompson had some responsibility for what happened here. The fact that he was off of his medication, the fact that he had taken K2. I think there's mitigation, the fact that this was the pandemic. But I do think that we can concede that he had responsibility and culpability for what happened. And he pled guilty, and we are not arguing that he wasn't guilty. But what we're arguing is that 7 years in prison is sufficient to punish him for the degree of culpability that he had, and is much more proportionate to his punishment, and frankly, may make our community safer.
How do we get from 9 to 7? Like, what's the calculus that says that 7 is better than 9 just because it's less? And that captures what happened? Is that how we make the determination?
It's just our recommendation of what we think is proportionate. Of course, Your Honors can reduce it by any amount. Even a year would be better. He could have received as little as 5 years. So,
and to be clear, the trial judge, the sentencing court, did reduce it from what the people recommended, right?
Yes, the court reduced it by 1 year, but this court is fully empowered to extend even more mercy than that trial court did, which we think is not only appropriate but necessary in this case, given that Mr. Thompson did commit these crimes while he was under the influence of psychotic delusions. Unless Your Honors have anything else, thank you.
Am I correct? Are you Miss McAlmont? Are you a law student?
Oh, no, sorry. I'm the attorney who supervised her, Elizabeth
Okay.
Batkin.
All right.
Thank
I
you.
was like, if this is a law student, boy, you're gonna really rock. Thank you. Have a good day. All right. K versus Citibank.
Good afternoon.
Waiting for your adversary here. Okay.
Good afternoon. Oh,
You may proceed. That's a bathroom break.
good afternoon, Your Honors. My name is Stuart Blander, and I represent the appellant Sophie K. The referee erred in
Counsel, can I just get one preliminary thing out of the way? Was there a motion to re-argue or renew below?
Yes.
Has it been decided?
It has not.
Okay, thank you.
It was bouncing between the referee and the IA judge, and it finally landed with the referee.
Okay.
All right. So the issue, the referee erred in holding that all of the items in the safety deposit box that was opened by Sophie K, that was paid for by Sophie K, and in which Sophie K was the sole owner, but to which her husband, the judgment debtor, had access, were fair grounds for the judgment creditor of the husband to get at.
When we're talking about a safety deposit box, do we delineate by item as to the tenancy of the box or the ownership of the box? Or do we just not say this is a box that has a bunch of things in it and they own it as joint tenants?
Well, you could say, well, I think the answer—
Does the law require us to do that?
It is always the judgment creditor's burden to show, even in a joint tenancy situation, and we cited a bunch of appellate division cases for this proposition, that the particular property that they want to get at is property of the judgment debtor. Now, there's
And the property here is not the safety deposit box and its contents
property is the
therein.
contents. Now, what they said in this case and what the referee said, because there was no direct evidence, the evidence was quite to the contrary. For example, the referee specifically held as a fact that the items of women's jewelry, you know, the brooches and the earrings and all that stuff, were the property of Sophie. She testified credibly they were gifted to her or they were bought to her, and they were placed in the box. But the referee said that essentially said that didn't matter because of this statutory presumption of 675 of the banking law. And what that says is, when you have a joint tenant a situation, under some circumstances, there is a statutory presumption that it's owned by both the husband and wife.
Is that what the statute says? Under certain circumstances?
Let me say certain circumstances.
Okay.
The case law says, in order to invoke the statutory presumption, there must be specific language of survivorship. And I apologize, Judge, the statute doesn't say that. The cases say that. Specific language of survivorship. And that applies even in the joint tenancy context. And we cited cases that say that. So you have to show that there is this language.
Except that in the case of a safety deposit box, where there are husband and wife, like in this case, are named as owners, in the event of the death of one, the other could go and take everything out, and the bank can't say anything.
Maybe yes, maybe no. What I know is, this court a couple of years ago.
Under what circumstance could the bank say no if I am a named person on the
Because
safety
you
deposit
still
box?
need, because you still need the language of survivorship in order to create the presumption that works in favor of the judgment creditor, which overcomes the fact that there is no
Counsel,
evidence.
we're not talking about the judgment creditor. The question was, if both husband and wife are named as owners of the box, can either of them, upon one of them dying, go and get whatever's in the box?
The answer is, that's a good question, and I'm not trying to fence with you. I don't know the answer to that question. The reason I don't know the answer to that question is, most importantly, that there is no account or safety deposit box renter agreement in the record. If there was one in the record, then it might say, on the death of A, B gets to go in. But it's pure speculation. And you have to contrast this case from a couple of years ago. This first department decided the New York Community Bank case, which was a situation also of a safety deposit box with a husband and wife. The husband is the judgment debtor. The wife says, you can't get my stuff. And this court said, you can't, the judgment creditor could access it. But there were two extraordinarily significant differences which show why this case has to come out differently. The first difference is, in the New York Community Bank case, there was a specific account or rental agreement which had the language of survivorship. That agreement does not exist here. And in fact, this court cited an older case, I think it's called Matter of Brown, which specifically, and quoted the language. And the language in that case is, if A dies, then B gets everything. So the presumption applied there. The second difference is, and it's a critical difference, in the New York Community Bank case, all there was to rebut the presumption, because the presumption can always be rebutted, the cases say, as well as this court said in New York Community Bank, by actual evidence that the stuff is owned by someone other than the judgment debtor. In the New York Community Bank case, there was no evidence. There was just a lawyer's affidavit, which was meaningless. In this case, there was actual testimony, and not only was there testimony that the trier of fact, the referee, specifically found to be credible, that all of these items of women's jewelry were the property of the wife.
That's part of what is in the box, but that is not the entire contents of the box, right?
Correct. There was some stuff that was not items of women's jewelry, that was items that could be worn by both men and women,
and which the referee did not credit your client's testimony in that regard.
That's absolutely correct. And that's why I'm not pressing on appeal that the referee made a mistake in not crediting that testimony. All I'm asking for on this appeal is that if the referee found that the items of women's jewelry belonged to my client, the only way that the judgment creditor, if I can just finish this thought, if that's okay, the only way the judgment creditor could get at that is by invoking the statutory presumption. And they can't invoke the statutory presumption because the express language of survivorship, which the cases say is critical, even in the case of a joint account, and as this court—
Counsel, you're repeating yourself.
I'm sorry.
You've said that like 3 times already.
Then I'll sit down.
Thank you.
Thank you, Your Honor. May it please the court, Joe Margolis from Quinn Emanuel on behalf of Respondent Fisher Island Holdings.
So what is the impact of the fact that there's no written agreement that governs this?
There's no impact in this case because the nub of the argument that the other side is making is that the express language of survivorship is necessary, but it's not. The counsel conceded that it's not present in the statute, so it's not imposed by that. And although he cited some cases, they arise in a completely different context. All of the cases that he cited, first of all, none of them come from this court. I believe it's a line of cases that come from the third department. They all arise in a very different factual situation in which the only issue is the right of survivorship, because in all of those cases, there was a joint account and one of the account holders has died. We've cited many cases in our brief, and that's on page 18 and 19 of our brief, that show that there are circumstances much closer to this, where a judgment creditor is going after a joint account or a joint deposit box. And in all of those cases that we cite on those pages, the account was accessible to that judgment creditor, even in the absence of any evidence that there was survivorship language in the agreement. And I'll point actually specifically to the Signature Bank case from the second department. It's important in that case because there was no evidence anywhere in the record that whether in the signature card, in any underlying agreement, in any bank rules, was there any survivorship language. That issue was specifically briefed in that case. It's not discussed in the decision, but it was discussed in the briefs. Counsel argued that the absence of that language in any agreement made it impossible to apply the presumption under banking law section 675. The court, of course, rejected that agreement because it held that the presumption did apply. A similar thing actually happened in the community bank case. Although there was language in the agreement underlying the signature card in the community bank case in this court, the language did not appear on the signature card itself. And counsel in that case argued, based on the exact same line of precedent from the third department that applies, again, only in the decedent account holder context, that the presumption couldn't apply because the language wasn't on the signature card itself. And this is actually very important because the case law from the third department is very clear. Again, limited to this decedent account holder context, it's very clear that the language has to appear in the signature card itself. It's not good enough for it to be in another agreement that's incorporated by reference. But because in the community bank case, that language didn't appear on the signature card, this court could not have decided community bank the way that it did if we actually imported the law from the third department in a totally different context into this context. Again, every court to have decided this issue without that specific language of survivorship in the context of a joint account or a safety deposit box for joint creditors who are alive has held our way, and no court has gone the other way. And to address your question further, Your Honor, even though there's no agreement produced in this case, and there's nothing we could do about that, unfortunately, the bank didn't have a copy and Mrs. K didn't have her copy, there is plenty of evidence that came out at trial that supports the presumption that this is a joint account. There was the signature card that was produced that showed that both Mr. and Mrs. K opened the account together in 2014. There was an access record, and that's on pages 367 through 368 of the record.
He accessed the box way more than she did.
Precisely, Your Honor. Literally 9 times out of 10, 27 times Mr. K accessed the account, 26 of them alone. Mrs. K accessed it, I believe, 3 or 4 times, 0 times since 2017. So it was very clear that Mr. K felt entitled to access the box, and there was actually testimony both from the Ks and from the representative from Citibank that he had unfettered access, unlimited access to visit the box, put things in, take things out without permission, authorization, or the presence of Mrs. K. And
you know that because there were a bunch of cufflinks and watches.
Thank you, Your Honor. Absolutely. I think that's...
The deposit box, and the referee did not credit the wife's testimony that some of those watches she wears.
I agree completely, Your Honor, and I think that was a very well-founded credibility determination from the referee. I mean, I believe the evidence in the record is that Mrs. K did not recall how many watches were in the box, and in addition to miscounting them, didn't recognize many of the watches, identified tuxedo shirt studs as cufflinks, which would be a very understandable mistake for someone who doesn't own those items. But if you claim to own those items, it's a much less understandable mistake, and along with other issues with credibility, contributed to the finding by the referee, which we submit, and it seems is undisputed, is well-founded in this case. And if Your Honors will permit, I'll move on to one more point. I don't think I need to belabor the point of the credibility determinations. But the idea that we can pick and choose and parse the items in the account so that we can decide, well, this item belonged to Mrs. K and this item belonged to Mr. K, that's not supported by the case law either. If you look at the community bank case, what it says is, and I'm reading here, if the presumption is applied, each named tenant is possessed of the whole of the account, so as to make the account vulnerable to the levy of a money judgment by the judgment creditor of one of the joint tenants. And in this case, essentially what Mrs. K is asking you to do is to pretend that the presumption doesn't apply, even if it does. You can see on page 918 of the Signature Bank case what happens if the presumption does not apply. Only then do you go and look to each individual account holder's partial ownership of the account. But what they're asking you to do is to do that even though here the presumption should apply. That's inconsistent with the case law, it's inconsistent with this court's decision in Community Bank, and respectfully, if there are no other questions from your honors, I request that you affirm.
Thank you so much.
Thank you very much.
Yeah,
Counsel, how do you distinguish this case from the Community Bank case?
I distinguish it in two ways. And I'm looking at the Community Bank case. The Community Bank case, this court held, quote, by relying on the terms of the rental agreement, NYCB met its burden of establishing Ari and Rachel, the husband and wife, as joint tenants with right of survivorship of the safe deposit bank account. And the court then went on to quote the language of the rental agreement that contained this language of survivorship. As counsel indicated, there is no such evidence in this case. And in the absence of such evidence, the statutory presumption doesn't apply. And if the notion that you didn't need express
In
language...
what case do you cite for that proposition, that it doesn't apply?
The cases I cite on pages...
Which is the one that you most rely on for that proposition?
There is a third department case that we cite in our brief, which is called the State of Corcoran, 6383rd93. Then on
Anything
from this court?
downstate? Yeah.
I'm sorry?
Anything downstate?
Yes. What I cite, what I rely on is the Community Bank case. It is inconceivable to me that this court would have gone out of its way to say, quote, by relying on the terms of the rental agreement as the way of satisfying the predicate.
But you are assuming that that means that in an instance where there is no agreement available, as in this case, right, neither side has the copy, right? It's not that it doesn't, that there wasn't one, neither side has a copy of it, right? So you're saying once that happens, that's it.
That's
the court can't look at other indicia
That's
and other
I'm sorry, Judge.
and other evidence to decide whether the burden has been met.
The reason I'm saying that, Judge, is because of, number one, if I may.
You can answer the question, yes.
The reason I'm saying that is because of the fundamental rule that with respect to any presumption, it's the burden on the party seeking to invoke the presumption to satisfy the conditions precedent. And the condition precedent here is this language. And if I could just answer
No, that's
Your Honor's question, no?
No, I think you've answered it. Thank you.
Thank you.
People versus Darrell, no, that's Global Bank versus 43 Mott Realty. Okay, you may proceed.
Thank you. Good afternoon. James DeCristofaro for the appellants. This is a commercial foreclosure case, and there are two loans, one by New Bank, which is the second loan, not at issue here, and another is by Global Bank, which is the first loan, the first mortgage that is at issue here. The two cases are related, and I'll get into how momentarily. There are two separate cases, one for New Bank, one for Global, and there are two separate appeals, one for New Bank.
So we know the record. Go ahead,
It
please.
would be most helpful if you focused on whether or not counsel had authority to enter into the stipulation.
Absolutely. So the answer is no, and the reason is, and this I understand this is a very high burden for us to show, and if you sort of go back and examine the facts, there's a lot of information here with
We have
respect
a notice
to.
of appearance in the court by counsel. So tell me what happened or what evidence there is in the record that somehow trumps that.
Right, so there's a couple of things here.
Seeing as he appears, he files motions, responds to motions. So how is he not counsel authorized to act on behalf of the client?
Right, so he is authorized to act on behalf of the client. However, if you look at the record that we submitted on appeal, there are two sections that sort of obfuscate the authority, I believe. The first is with respect to Mr. Basil's affidavit that he submitted in the record, and the second is the emails. I believe they're on page 148 to 153 of the record, where my clients who do not speak English as a matter of first impression, they do speak broken English. However, they fully didn't understand what was going on, and I believe that that was clear in the context of those emails and that correspondence.
Their lawyer only spoke to them in English?
Correct.
Or in their native tongue?
No, in English.
So did they
only.
have a translator whenever they had to speak with their lawyer?
They understand some English, but not all English. There was a miscommunication. They had no idea what their attorney was doing, and the
Counsel,
attorney was not authorized.
Please, don't tell me that clients who are taking $10 million loans don't know what they're doing.
Right.
Okay? Because people who don't know what they're doing don't get $10 million loans. So please dispense with that kind of argument.
I understand. I understand.
Please.
But the point here was that they didn't understand what their attorney was doing. They didn't understand nor authorize their attorney to enter into, basically give up all their rights and say, yeah, you can have the judgment of foreclosure, no problem.
When did they realize that that their lawyer had entered into this stipulation?
Shortly before we filed the order to show cause to vacate the judgment, which the judge signed, but then later decided.
So a year went by after the settlement and they knew nothing about it.
It was correct. It was when we reviewed the record, we spoke, and they had no idea that their client, that their attorney had signed this on behalf of their, on their behalf, and basically waived all their rights.
Why wouldn't the other side, what evidence do we have here to establish that the other side wouldn't have believed that the lawyer had apparent authority to enter into the stipulation?
Well, there's a couple of things to answer that question. Number one, there's no real record below because we weren't able to create it. So we believe that it should be put back to the lower court so we can create the record. But as we stated in our appellate papers,
What does that mean?
Well, there is. What does that mean? That means that there was a conflict of interest that the attorney Basil had in acting for the appellants here, and that derives from, first of all, he had a relationship with a new bank broker. He represented a new bank broker to begin with. Second of all, Global.
How does any of that affect his apparent authority with regard to the other side with whom he signed the stipulation and the court that accepted it? How would they know about any of that?
Yeah.
And therefore, why didn't he have adequate apparent authority to enter into the stipulation?
Because of the, in my opinion, because of the way that the record comes as we have constituted it in this appeal, there are a lot of unknowns. There's a lot of things that happened below. For instance, Global received $500,000 to settle the new bank matter, but didn't do anything about it. Didn't cure the cross default, accelerated its loan, and got a windfall.
So I'm glad you mentioned that because you say my clients didn't know anything. A whole year went by and they didn't know anything. So they give $500,000 and they don't have finality on any of their cases and nobody's asking questions.
That is in the context of settling the new bank action so that they could resolve everything.
Right, and so they had no piece of paper telling them that.
Telling them.
And they waited for a whole year.
I don't think
after giving $500,000.
They did that in the context of resolving all of the disputes. That's what they understood was happening.
That is my point. But you'll have time on rebuttal.
Thank you.
The court. Yes. Gail Spindler for the respondent, Global Bank. It's our position, of course, that Mr. Basil had.
Lower the microphone so we could hear you.
It's our position that Mr. Basil had, if not actual authority, then at least apparent authority. Mr. Basil submitted 2 affirmations in the lower court, attaching all his emails, or a slew of his emails with his clients. And he explains to them that I don't think, having read the undertaking deposit and forbearance agreement, that you can defeat Global Bank's motion for summary judgment. However, I think you should focus our energy on the new bank case, as well as your money. He said that these people were concerned about legal fees, and from the correspondence that are next to his affirmations, they understood, and they did nothing for, as you said, almost a year. Actually, it was on the eve of the date of the auction sale when they came up with this new theory. Now, not only did Robert Basil file a notice of appearance, he filed a verified answer to the complaint. So he had the verifications were signed by both Kenneth Yee and Penny Chung. No affirmative defenses were raised to the validity of the Uniform Deposit and Forbearance Agreement that these people signed with Global Bank. The terms of the Global Bank forbearance agreement were very specific. It wasn't that Global Bank undertook the obligation to settle the foreclosure action with New Bank. It said, we're putting this $500,000 in a restricted account in your name. Come to us with your settlement agreement.
Once you settle with New Bank.
That's right. And if you need this money to settle with New Bank, it can be used for that purpose. But you have to come to Global Bank with those documents. It wasn't our obligation to do a settlement, nor did we have the authority.
So that agreement was in essence a forbearance agreement, meaning we're not going to go after you. We'll give you an opportunity to settle with New Bank.
Exactly. We gave them 6 months.
Now, when was the first time that they learned about the stipulation?
All right. Now, would I know exactly when they knew about the stipulation? The stipulation was dated in December of it was signed in December 2023. The motion for summary judgment for Global Bank was submitted in 2024, I think. And when did they know? I wouldn't know when they were aware. You know, I don't get involved in the discussions with themselves and their attorney, but they did continue to vigorously defend the New Bank action, as well as the cross claims that the December 2023 stipulation severed from the Global Bank matter, so they could continue to litigate with New Bank.
And who was representing them?
Robert Basil.
The same attorney.
Right. Okay, thank you.
You have 2 minutes on rebuttal.
Thank you. So there's a fundamental disagreement as to this $500,000. It was paid to Global to settle the New Bank action. That's what our position is. And why else would they pay Global $500,000? That's our whole point.
Because you owed Global money.
But we were
and there was a default by there being an action by New Bank instituted against your client. That was a default on the Global agreement. So there, it's not nonsensical that in exchange for, I won't also institute a foreclosure proceeding against you. I'm going to give you 6 months to work it out with New Bank, and I'm going to hold this $500,000 to make sure that you do, because you owe me over $6 million.
It is.
So I don't understand that argument.
It is absolutely nonsensical, and the reason why it's nonsensical is because the appellants have been current on their mortgage payments throughout the whole case. Before default, after default, before the judgment, after the judgment. That is why they gave $500,000 to Global to settle and pay New Bank. It's in the record.
Why wouldn't they settle and pay New Bank themselves?
I don't know. Because they agreed with Global. Global said that they would do it. And
That's
in
what
terms
the
of
forbearance agreement says?
yes, That's our
what it
interpretation of
says?
it. That's what our interpretation, yes.
I thought what the forbearance agreement said is, we won't sue you while you work out your issue with Newbank.
It all, first of all, it's not in the record below, but second, excuse me, it's not in the record on this appeal, but second of all, what it does say is that you're giving $500,000 to us in the context of settling with Newbank.
So you're telling us what a document not in the record says?
Yeah.
Well, the court was asking about it, that's why
But
I
please
answered
don't.
it. So in terms of the apparent authority, it says, and with respect to stipulations, this is the Childs versus Lewitt case that we believe I cited in our papers, but the site is 151 ATD 318. The court, and I quote, "The court has control over stipulations and power to relieve from the terms thereof when the parties can be placed in statu quo. But the stipulation will not be destroyed without a showing of good cause therefore, such as fraud, collusion, mistake, accident, or some other ground of the same nature." And we submit that in our papers. It very clearly shows how this stipulation should be disregarded in the substantial interest of justice. Thank you.
Rejo versus YYY 62nd Street. You may proceed.
Good afternoon, Your Honors. Should not do that. Sophia Uveda from Kahanafeld for Defendants Appellants. Central to this motion to amend to add an affirmative defense under CPLR 3525 and 3018 is the context of what we're doing. Unlike a counterclaim, 3018 permits a defendant to assert traditional affirmative defenses like laches, res judicata, collateral estoppel, but it also permits defendants to plead facts which don't appear on the face of plaintiff's pleading or which, if not pled, would surprise the plaintiff. That is a much broader context of what the courts recognize as an affirmative defense versus a claim where you have very particular elements that you have to plead. And we raise that because the dispute below became with the court saying, you didn't make out your elements for a counterclaim of fraud, and that is common law fraud. And that is not what we are trying to do. We're not seeking a counterclaim. We are trying to plead facts in our answer that will let the parties explore what we found to be suspicious or concerning facts linking the proximate causation of the medical injuries and the happening of the accident and certain facts surrounding the accident.
Would you be foreclosed if we uphold the court below, would you be foreclosed from exploring that possibility of fraud? Or actually, this was post-note, right?
No, we filed our motion pre-note of issue.
Pre-note, okay. Is it post-note at the moment?
It is post-note at the moment. Plaintiff subsequently filed a note of issue.
So if we were to reverse, would you seek to, I mean, in other words, what's the practical effect of having the affirmative defense? Do you get to more discovery or what?
Well, yes, that is the practical effect of what we want to do because this court...
And that's precisely why the court said no. Right. Because you knew these facts early on.
Yes.
The allegations that you are talking about, the people on the job site could have told you that day one. So there's no, I don't understand why you needed all of that to assert it in the first place.
When did you learn about the doctor and the charges against the doctor?
The charges against the doctors came in starting, I think it's mid-2023. I can't remember when these doctors were sued.
In terms of the...
Right, and you filed, I'm sorry, one second, and you filed you filed a post-discovery motion on January, I'm sorry?
This is while discovery was still open.
On January 29, 25.
Correct.
2 years
It
later.
says filed post-discovery.
No, this is a pre-note of issue. This was, the note of issue was subsequent.
Discovery completed already? Maybe the actual form had not been filed, but was discovery completed under the compliance conference dates that have been given?
There were certain open issues, and I'm happy to go into that. One of the issues was during plaintiff's deposition, plaintiff was asked about his litigation funding. At that time, plaintiff's counsel directed him not to answer, saying that is not relevant, we will not be answering that. In making this motion, in asserting these defenses, we were trying to create a record to make sure that we have standing to say, no, we want to go back. We want to finish up this deposition. We want to get these answers that we had asked and we were prevented from
You're not
getting.
entitled to the funding information unless you set forth and proffer a basis to show that the plaintiff, not that his doctor, not that his lawyer, that the plaintiff was engaged in some kind of fraud.
Which is what we are trying to put forward.
In terms of that, though, didn't the trial court already grant summary judgment on the labor law claims?
That happened after the judge denied our motion, and this is going to damages. And again, our major issue here is the damages, which we do point out. The plaintiff goes to the hospital, and he's in the hospital for a number of days, and they do CTs, X-rays, MRIs, not once, but twice.
Because he forced them to do that, right?
Because they were concerned.
He's the one who decided, I'm going to have an MRI. And he was able to make that determination himself, as opposed to the doctor.
No, those doctors, we believe that those MRIs for the first week that he was in the hospital were absolutely proper and accurate, but they all came back clean, showing that he didn't have any injuries, no herniations, no broken bones, nothing. Everything came back clean. He had 2 sets of MRIs during that first week that all came back clean. He is discharged with clean MRIs, and then he starts treating with subsequent doctors who are then subsequently
named. Are you saying that if someone has a clean MRI, that means that that person isn't feeling pain, that they should not go to the doctor for?
Yes, so subsequently, Dr. Kolb looks at...
Counsel, stop. I just asked you a very direct question. Are you saying that someone who has a clean MRI is not entitled to go to the doctor if they feel pain?
They are entitled to go to the doctor.
Great. That was my question. You're out of time. You'll have time on rebuttal.
Good afternoon, Your Honors. May it please the Court, Jonathan D. Moran, Grab and Associates for the respondent. I'd just like to point out that the court below was absolutely correct in its holding that amendment of the answer to assert an affirmative defense of fraud was not appropriate in this case. In order to amend a pleading, it has to not be patently devoid of merit and palpably insufficient. And in order to properly plead either a cause of action or defense of fraud, it must be stated with factual particularity. That was not done here. The proposed amended pleading in
What was missing from the elements of fraud? I know that you argue about reasonable reliance was missing in terms of the allegations. What other elements of fraud, if any,
Well, thank you, Your Honor. I would argue that there are no facts in the proposed pleading whatsoever. They do not state what material misstatement of fact that the plaintiff made and to whom it was made. They don't state that he made any such statement knowing of its falsity.
I mean, overall, they're claiming that the accident was a sham.
Well, I mean...
That's not enough to say fraud, right?
That's not fraud. I mean, really, a lot of the arguments that we're hearing today and also in the papers are essentially, either for a damages trial or if you want to assert somebody doesn't have credibility, a witness isn't credible in terms of what he or she saw. That doesn't mean there's fraud present. There has to be a knowing misstatement of fraud with the intent to induce justifiable reliance. None of that is present here. And just with regard to the happening of the accident, irrespective of the fact that summary judgment has already been awarded by the trial court below, obviously not an issue here today, this was a documented accident. The FDNY showed up. The Department of Buildings showed up. There's a daily log report, all indicating that he fell into the trench, that there should have been a guardrail on the trench, and that there was not. So, I mean, I don't know what the fraud here is. I don't think there's any fraud here, and I think it's really just this attempt to try and sort of, well, I don't think that they've met their burden of trying to amend their answer to assert fraud. I submit the record is bereft of any evidence of any of the elements of fraud. And I don't think the trial court misapprehended what they were trying to assert in their answer, whether it was an affirmative defense or a counterclaim. I submit there's no difference in the standard to be applied. There has to be factual specificity. In the Bank Lumi case, they tried to assert, the defendants there tried to assert in their answer, both counterclaims of fraud and affirmative defenses, both of the proposed amended counterclaims and causes of affirmative defenses were dismissed for lack of factual specificity. So they don't get treated differently with respect to how they have to be pled. There have to be facts, specific facts establishing the elements of fraud. There are none here, none. And I submit that the trial court's order should be affirmed.
One of the things that I found curious was they seem to suggest that your client was holding a jackhammer he didn't need to use at the time, and that he was standing near this unguarded hole that he could see is unguarded, and that fact is at least some indication that perhaps he staged this accident himself. That he basically threw himself into the hole in order to create an accident.
I suppose that might be their argument. I find it to be rather creative, and I don't think it's supported by the record at bar.
Okay. All right.
Thank you, Your Honors.
Counsel, you have time on rebuttal.
I want to
Got 2 minutes.
address that and to summarize the medical records and to show that we were not trying to delay for no absolute reason. What we're seeing in the hospital records immediately after the accident is, for instance, a clean cervical MRI. Then 2 years later, or a year later, he goes to Dr. Kolb, who then finds a herniation at that disc for a cervical MRI that previously came back clean, and says there is now a herniation that's causally related, and then plaintiff undergoes a cervical fusion.
Counsel, why is it that you can't assert all of these inconsistencies at a damages trial without having an affirmative defense of fraud?
We think we should be able to, but the reason we're doing this is because trial courts below have been inconsistent in letting certain evidence come in if you have it versus you don't have this affirmative defense out there. And I just want to point out, I know the medical description of what we're giving.
But I don't understand, because I don't see anything wrong with what you just described, and I don't understand why your office perceives that they would be stopped during a trial from questioning a plaintiff or the plaintiff's expert to explain how it is that right after the accident he has a clean MRI, and then the next MRI, there's a herniation, right? There's no reason in the world why a court would not allow you to explore that.
But if there is no reason in the world, then permitting us to amend our complaint.
You don't have to amend to say it's fraud to make that assertion. And it's my point, right, and it's the court's point below. You can make whatever argument you want to attack the credibility of the plaintiff, but if you want to say it's fraud, then you've got to plead it with particularity.
We're not just saying it's fraud. And again, this is not a new concept. The concept of saying it's a staged accident has been pled before in no-fault claims. It has been pled probably for the past 25, 100
Get to your point. I want you to notice you got a red light. Go ahead. Get to your point, but I'm going to let you make it.
And I just want to finish up with, Your Honor, yourself and Justice Mendez, in November, permitted somebody to amend to assert an affirmative defense sounding in fraud.
You know why? Because there was a lot of indicia in that case of the fraud. So when and the party proffered that evidence. I don't have that here. I don't have enough here.
If the court, we believe that this is comparable to what you saw in Tavares based from the underlying record in the court's decision.
Counsel, I read that whole record. I'm telling you, it was replete with indicia. Here you have one or two things, and you're saying you want us to make a leaping
No, we just want to be able to plead it. And then if we are unable to show and unable to meet our burden of proof on an affirmative defense, plaintiff can move to dismiss.
Well, let me add it. Let me add it when I haven't even demonstrated I have enough to plead it. Counsel, please. That's not how the law works. All right? But we have your arguments. Thank you so much. People versus Mororrow Bavar.
Delorny Namoran on behalf of the Legal Aid Society representing Mr. Bavar. Respondents in this case concede that the appeal waiver is invalid, also concedes that the court erred when denying the suppression hearing, but however, we disagree with respondent in its assertion that this was harmless error. Your Honor, the standard to find harmless error in a plea is extremely high. The Court of Appeals in a unanimous decision in People v. Robles held that if there is any reasonable possibility that the error contributed to the plea, the error cannot be considered harmless.
Counsel, with regard to the argument that there was overwhelming other evidence of the defendant's guilt, how do you respond to that?
I think, Your Honor, that is just their opinion and not fact. One, the arrest happened in January of 2019. There is no arrest until May 2019. 4 months. The police report had no names. It had no description. They made one arrest the day of the arrest, and then the police report said 4 other people were part of this crime. And that's it. No other pertinent information. This idea that there was a camera footage existed in January, but yet they still could not find Mr. Bavar. In fact, it is the complainant who found Mr. Bavar in the laundromat. So to say that there's overwhelming evidence when you had an open case for 4 months, I think is misleading. Also, we don't.
You can have an open case and then thereafter develop overwhelming evidence, right?
That could happen, Your Honor. I agree with you. That could happen.
So just it being open, the case being open for 4 months doesn't preclude the notion that there was overwhelming evidence of guilt.
Well, not only that the case was open, Your Honor, they had no identification about who committed the crime. They had no information. It's not like in May they got new evidence. The evidence they're claiming—
Well, no, what they got was an identification from the complaining witness about who committed the crime, because on the day of when the other co-defendant was arrested, the complaining witness was hurt and EMS was trying to rush him out of the apartment so that he could get treatment. So there was no time to do any additional identification procedure.
So, Your Honor, we don't know how long complaining witness was in the doctor, emergency room, whatever the case is. There was a gash on his nose. What we know is that video existed, and let's just say it was a month. In February, that video existed. They could have sent that video or showed that video to the complaining witness and asked for an identification via video. We do that all the time.
Well, in terms of the quality of the video, what does it even show anyway?
All it shows is that there's a group of men who exited or entered a complainant's apartment. It does not show the actual assault.
So could we classify that as overwhelming evidence of guilt?
I think people can make descriptions about the facts, but we don't have a full record because we didn't go to trial, so that's why they have an opinion about their facts, but I do not believe that it is overwhelming. Also, Garcia, who's the author of People v. Robles, they found a gun on Robles, and the court stated when there are facts in the records that make possible a part of the analysis, the court must still determine that there is no reasonable possibility. So just focusing on the evidence, which is the videotape, whether they think it's overwhelming or not, does not diminish the high standard and the high bar, which they wrote is rare, because the record must leave no question whether the erroneous suppression hearing impacted my client's ability to plead,
What about the argument that the statements were trivial and non-incriminating, and so therefore they wouldn't affect his plea assessment?
So, Your Honor, I think the respondent should not be allowed to make those arguments when they wanted the hearings to be, those statements to enter. They found it to be probative value. In fact, respondent's brief on page 14 says, respondent even concedes that the statement could be used to establish consciousness of guilt. The statement that he just had something against me is the part that I think establishes some form of relationship, but you can't ask for a statement to be entered. We have an entire hearing. And then you win that hearing, but now on appeal, you're saying it's not that relevant. You can't give us a notice, claim probative value, and now on appeal, you concede there was a mistake, and now you're changing your position as a respondent. I don't think they should be able to make that argument. They should be precluded when you wanted the evidence in, and now you're claiming it's not useful.
Can you explain the mechanism of how these statements having come into evidence would have affected the defendant's decision to plead?
Okay, so it establishes relationship. If the client had never, I'm not here to dictate what my clients say, they should say nothing, but he just has something against me, establishes relationship that they knew each other. Because when the officers come in.
No, I'm saying, I think what my colleague is getting at, if you don't mind, is that one of the factors we have to consider on the issue of whether this error on the Miranda was harmless is whether that impacted his decision to take a plea. So the statement is coming in based on the ruling by the court. What is the impact of that ruling on his decision to take a plea that one can say it was harmless error?
So, Your Honor, the reason why you don't think it is harmless is because the statement would come in at trial, and at trial, that would help establish that Mr. Bavar knew the complaining witness, and therefore—
But we knew that from the body-worn camera footage, right? Because he lived upstairs.
Just because he lived upstairs, there's a lot of people who live in the building, I'm assuming it's New York City, does not necessarily mean that he was the person who was—
The other co-defendant was essentially his brother-in-law, and it was told that during the body-worn camera footage, they talked about this encounter, a fight happening, and that they went downstairs about the noise.
So, well, the body-worn camera information, we don't know who was going to testify at trial. That's the biggest problem is we don't have a trial, so we don't really know how all this evidence was going to roll out at trial. But what we believed is that this statement was going to be part of the evidence, probably entered at trial. We know prosecutors don't have to enter everything. And as the evidence against Mr. Bavar, because these are his statements, his exact statements, not statements from my brother-in-law, right? Clear statements that I know this person, that would increase the chances of a conviction. And so, therefore, it impacted his decision, especially given the fact there were other things weighing about, it's his first ever crime, and he made efforts. Seeing the light, I have rebuttal.
Thank you. You beat me to the punch.
John Cheever for the people. Good afternoon, Your Honors.
Good afternoon.
The Court of Appeals in 2013 said that there may be instances where the failure to grant suppression does not affect a defendant's decision to plead guilty because the challenge proof is too trivial. This is that case.
How is it too trivial if it's acknowledging that they know each other, that there's somewhat of a relationship between the parties?
Well, Your Honor, I think to say that the statement acknowledges that they know each other is a little bit of a misrepresentation of the statement, which we haven't yet said here. But the statement that was not suppressed was, I didn't touch that man. I don't know that man. I didn't do anything to him. He just has something against me. And so counsel has latched onto that last sentence to the exclusion of the sentence, I don't know that man, which clearly establishes there is no relationship.
But the last sentence clearly establishes a relationship.
Well, Your Honor, in the context of when the statement was said, the victim walked up to the defendant, pointed at him, and immediately afterwards, police handcuffed him. And so the defendant was in a situation where he knew he had to explain, why is this guy pointing you out and causing us to arrest you?
He could have said, I don't know why he's pointing me out.
He could have said that.
Yeah, but that's not what he said. He said he just has something against me. Now, why would the complainant have something against him if they didn't have some type of relationship before?
Well, that's a fair question, Your Honor. I think another fair question is, why would he say, I don't know that man, in the same statement if there is a relationship?
That is the argument that the defense is making, that it goes to consciousness of guilt. In the event that he were to go to trial, take the stand, and there you go. Now the prosecutor has him on the stand and can ask him, you just denied knowing this man when the police first approached you.
So, Your Honor, you bring up a good point, which is the the possibility of the defendant taking the stand. But actually, that mechanism for the prosecutor to cross-examine them is not implicated here. The court did not make an explicit voluntariness ruling, but if you look at the court's decision, the court did say that the statement was admissible, which implicitly acknowledges that the statement was voluntary. And so under People versus Harris, that's a different standard. So still, even with this decision, even if this decision had come out the other way, and the court had said, I am suppressing this statement, that does not preclude the prosecutor from doing just what you described. And that's part of why this statement and this suppression ruling is so inconsequential to this case.
But now, going back to the trial, this is something that the prosecutor can bring out, okay? He said he didn't know me. Then he said he just has something against me. And the complainant is saying that this defendant assaulted him.
Yes, that's right. That's right.
So now how do you undo that if you're the defendant?
I'm sorry, how do you undo that?
Yes, how do you challenge that now? Those are your statements that you gave to the police that are now coming in against you.
So, Your Honor, I think it's clear from watching the video, which is part of the record, that the defendant, when he says he has something against me, is not acknowledging a relationship. I think that is very clear. And I would say also that at trial,
Why would someone who doesn't know you have something against you?
because he's trying to explain, if you watch the video, what the cop is
You
asking.
should never assume that we haven't.
Fair.
Okay?
I'm not.
That's the easiest part of the record to get through, my friend, is to go like this to a button. All right? So
Yes.
you should never assume that.
I'm not assuming. I'm not assuming, Your Honor. But what I'm trying to say is that in the context, again, in the context of the way this statement is made, the complainant flags down the officer, and then the video shows the complainant leading the charge into this laundromat, walking right up to the defendant and pointing at him right before he is put in handcuffs, seconds later, maybe 1 minute later. And that is when the cop asks, do you know this person? And so and then we get this flood of answers.
That question is intended to elicit not an exculpatory response, right? And that
that's
is
right.
precisely why you're supposed to Mirandize people.
That's right, Your Honor. That's
Okay.
right. And
So, but the issue here is whether there was harmless error.
exactly. The issue
And
is
you're saying that it's harmless because it doesn't matter. Had he taken the stand, you guys would have been able, under the case law, to cross-examine him on the statement, correct?
Yeah.
That's your argument.
So
Except that if the statement is suppressed and he chooses to go to trial and doesn't take the stand, you can't elicit that statement, right?
That's
So
right.
that evidence is now not before the jury. And all they have is somebody who wasn't able to identify someone from their building for 4 months. So how is that not harmless?
Okay, so there's a lot of ground to cover here, Your Honor, but counsel also described the video as showing just people entering the apartment and leaving. But actually, from the record, we know that that's not the whole story. The people's opposition, or the people's affirmation in support of their motion to consolidate, which we cite in our brief, describes the video as depicting the defendant entering and exiting the apartment. And that description of the video is not contradicted by the defense on the record.
But all it is in terms of it being overwhelming evidence of guilt, it's evidence of him going in an apartment and leaving.
It's video showing him going in an apartment and leaving right after.
Right.
It's the testimony of a complaining witness who's identified him as participating in the assault, and then it's the evidence of the injuries, the photographs and the medical records, which I submit to the court is overwhelming, and especially in conjunction with the tiny, tiny significance of this evidence. I mean, it's
So the overwhelming evidence of guilt is him going into the apartment, leaving, and the complaining witness 4 months later identifying him as a participant in this incident, and the fact that the complaining witness had injuries, right?
Yes, that's
Okay.
right. That's right.
All right, sure.
I'm also curious whether, with regard to this defendant, whether there are immigration issues raised by his pleading or not pleading or going to trial, and whether the harmless error issue has to be resolved, has to be addressed in that context.
So I think that you're getting at the waiver of appeal, Your Honor.
No, more generally, the immigration issues that might happen if he went to trial or pled.
Well, the fact that the court tried to work out an immigration-safe plea, as you guys like to call it.
Yes, so unlike Robles, this defendant says nothing about the suppression ruling after it happens. In Robles, the defendant, not counsel, specifically said, will I still be able to appeal this suppression ruling? This defendant says nothing, his counsel says nothing. The only concern that gets expressed with respect to him taking the plea is counsel saying, I thought this, some of the effect at sentencing of, I thought this was an immigration-safe plea. So that shows that she knew how to ask about areas of concern, and the suppression ruling was not an area of concern. This is not like Robles. This is not like Wells. There is no case like this where it's just a denial of involvement.
I really don't even understand that argument. Because one has nothing to do with the other. Not in my mind.
So that's right, Your Honor. They don't have to do with each other, but the argument is useful because what I'm trying to say is that the lawyer knew how to point out areas that they were focused on. And after 3 months, the suppression ruling never comes up. She doesn't say anything about it. Unlike in Robles, the defendant doesn't say, will I still have the opportunity to appeal it? Just nothing. But she does ask about the immigration consequences of the plea.
Because at that point, that was the most important thing. Her client had already lost the suppression hearing. What is there to talk about? I've already lost that suppression hearing. All I can do is appeal that. Now I have to deal with my client who is exposed to immigration consequences. So I just don't understand that argument.
That's fair, Your Honor. So let me point you then to People versus Wells, which is Court of Appeals in 2013. And in that case, the hearing court denied the suppression motion. The defendant pled guilty, and while he was pleading guilty, said he was not planning to go to trial if he got a negative ruling. So like these are cases where it's clear that it matters to the defendant. But here, where a simple denial of involvement is not incriminating in any sense. It is not consciousness of guilt evidence. It is not.
Although you argued that it was.
At best, but at best, any denial is consciousness of guilt evidence technically. But we're talking about such low probative value. There's no world where the
It's also consciousness. It's also a inner understanding of I'm innocent. It could also be that, right?
That's what any defense attorney would say. Is this
and,
is what an
and a
innocent
prosecutor, any prosecutor will say it's consciousness of guilt. I don't care what comes out of your mouth. Got it. All right.
We ask that you affirm. Thank you.
Got it.
Your Honor, I want to first start off by saying I do think that we take suppression hearings very seriously. Sometimes we don't even get those hearings. And to say that an error in a suppression hearing is so inconsequential is the time of the court and the two defense attorneys and the witness at the stand. So you win a suppression hearing. I don't know why you would now on appeal say it's so inconsequential. Plus, we are speculating what would happen at trial because it never went to trial. And that is what Garcia says in the majority. We don't have a full record to know the heart of a reason why someone pleads guilty. So we don't know what evidence would have came in. We don't know how a jury would have taken that evidence, how would have interpreted that evidence. Sorry.
Counsel, what if we were to reverse? What would be the next step?
Well, if we were to reverse
It
we
goes back to the trial court.
We go back to the trial court, and we have a new hearing, or
A hearing or a trial? You already had the
Wouldn't it
hearing.
be a vacature of the plea and you either go to trial or work out another plea? Isn't that what would happen?
exactly because it's clear that the statements were should have been Mirandized. Yes.
Thank you both. Have a good evening. Get home safe.
Yes.